I would.
May I please, your lordship? My lord, I beg to mention for listing of, my lord, motion items tomorrow, my lord. Eviction items, my lord. Tomorrow is the last date as per the notice, my lord. My lord, this is actually allowed us today, but my lord, due to this filing 7 petitions, my lord, that's why, my lord. No, it has not been listed today, my lord. Tomorrow, my lord, I am not pressurizing for today, my lord. Well, obliged, my lord.
May I please? For similar claim, my lord, regarding eviction, my lord, new motion matter, lordship. Day after tomorrow, lordship. Lordship.
May I please, your lordship, with the consent of the other side, I beg to mention item number 47. Lordship, we have submitted the adjournment slip yesterday, lordship. The matter may be taken after 2 weeks. Lordship.
We have a petition, lordship. Interim order, that may be continued.
I yield back, lordship.
May I, your lordship? Lordship, the matter relates to eviction, lordship, day after tomorrow.
Hey, please, Lordship. Lordship, I'm praying for listing a content matter, Lordship. It is come in orders columns, Lordship. Lordship. And fifth, Lordship. Yes, Lord. It is a. Oh, it's highly honest.
May I please, your lordship? Lordship, I beg to mention item number 43. Lordship. 43. Lordship, in this matter, the state has filed their affidavit in opposition. Lordship, we need some time to respond. Lordship. BP Sharma.
Item number 34, just covering the orders column. My lord, the order was, my lord, that rule was issued on 13/11/2025 with a direction that it will be listed in due course. So let it come in the hearing column, my lord, any day after 3 weeks.
No, this one.
Item 34.
Lordship, there's an interim order in this matter.
Yes, then. Well,
Interim may continue. Lordship.
May I please, your lordship? Lordship, I beg to mention item number 38. With the consent of the other side, they have filed their objection. Lordship will go through and file the rejoinder. Lordship, the matter may be adjourned 2 weeks. Yes, lordship. Obliged.
May I please, your lordship? Lordship, I beg to mention an item for listing, lordship. For day after tomorrow, lordship. For motion, lordship. It's a fresh matter, lordship. Yes, your lordship. Highly obliged.
May I please, your lordship? I would like to mention item number 48 of the daily list. As my senior Jain Saivara is out of station, may the matter may be adjourned for the day, lordship. Yes, lordship. Obliged, lordship.
Please, lordship, I beg to mention item number 50 supplementary list. The matter may be taken up any day after 5th of February. 5th. Yeah, 50, yes. 5th February.
5th February. Item 50 on the request made of the counsel for the petitioner stands deferred to be listed. In the week beginning from list on 11th February.
May I please, your lordship? I'm praying for listing of a matter on 30th for motion.
Fresh matter.
Fresh matter, your lordship.
When
It
did
was
you file it?
listed on 19th.
Filed on 19th.
No, it was filed on 17/12, but it was listed on 19/1.
All right. Day after tomorrow.
Yes, okay. Okay.
My lord, I beg to mention item number 35, my lord. Matter may be adjourned for the day, my lord.
35.
Yes, my lord.
On the request made by the counsellor for the petitioner, matter stands deferred to be listed after 2 weeks.
Wait, please, my lord. So this is motion matter. May it come on 2nd of February, my
2nd of February, all right.
Obliged.
May I please, your lordship? Lordship, I beg to mention item 20, lordship. This matter is in fact was, lordship.
Huh?
In fact was, lordship. So let it be closed.
Item 20.
Item 20, lordship.
You're Mr.
Yeah, Ali.
Mr. A. Ali. Counsel for the petitioner on instruction submits. If the writ petition has become infractious accordingly, the same should be closed. Your writ petition accordingly stands dismissed as infractious. Interim orders, if any, stands vacated. Pending IAs are also dismissed.
But I beg to mention item number 37, my lord. I am appearing for the sole respondent, my lord. 1 week time may be granted,
36, 37.
my lord. I have given consent, my lord.
This is a review.
Review, my lord.
You have taken consent of the petitioner.
My lord.
36, 37 on the request made by the respondent. Matter stands deferred to be listed after 2 weeks. It is submitted that consent of the counsel for the petitioner, review petitioner has also been obtained. List accordingly.
Obliging.
Given the list for observed item 57 and 58.
Malas, in this case, the client does not want the corresponding.
Does not want to press.
No.
Mr. Rekhi Saiwala, counsel for the petitioner. On instruction submits that the writ petitioner does not wish to press the petition any further. Accordingly, the writ petition stands dismissed as infractuous. Interim orders, if any, stands vacated. Pending IAs are also dismissed.
Both the matter.
Yes.
Great.
Daily list for motion item 1.
May I please the lawsuit kindly pass it for.
No passovers.
Well, in this case, when the requisition was moved, my lord, there was paucity of time.
Hmm.
The honorable court, my lord, verbally asked me not to evict them, my lord. So there is no order of stay, my lord, but I gave an undertaking. These 3 petitioners are not yet evicted, my lord. They are still inside the forest.
So what is the status now?
They're inside the forest, rest, and all encroachers have been evicted, my lord. And I have filed an affidavit to indicate, my lord, their only claim was that the place they are residing is beyond the boundary of the forest. I've annexed the map also, my lord, to show, my lord, it is very much inside the boundary, my lord.
Have they filed any rejoinder?
Yes, my lord. If my lord takes up my affidavit for a moment, my lord. These petitioners, my lord, earlier also filed a writ petition.
Hmm.
If my lord peruses my affidavit, I filed it on 17/11, my lord.
Hmm.
Page 62, my lord, may kindly peruse. After the case was moved, my lord, it was moved as unlisted, my lord. I wrote this letter to the government, my lord, department.
Hmm.
There was no interim order, but still they have not proceeded. Then, my lord, please kindly. I got order.
Hmm.
Annexer 1 of the Annexer 1, my lord, may kindly peruse, ma'am. The order starts at page 45, my lord. And my lord will kindly also take note of the fact that, my lord, there were in this writ petition,
Hmm.
besides these petitioners, my lord, there were total 59 petitioners, my lord.
Hmm.
So there is an order that, my lord, finds at page 50, my lord.
Hmm.
Page 52 is the relevant page, my lord, paragraph 19.
Yes.
Under such circumstances, issuance of a notice shall be necessary to form a subjective satisfaction which is in consonance with the principles of natural justice in as much as the same will facilitate a just, fair and transparent procedure which are facets of so and so.
The present writ petitioners were also part of the.
This proceeding, my lord.
Okay.
In view of the aforesaid, and the stand taken by the learned additional advocate general, this court is of the opinion that the writ petition can be disposed of by directing the respondent forest department to consider the representation of the petitioners.
Hmm.
Petitioners may also file a fresh representation within 10 days from today before the office of the District Forest Authority, Goalpara. District Forest Authority, Goalpara, to accept the representations filed by the petitioners and pass a speaking order by considering the grievances raised by the petitioners. So, my lord, this order is, my lord, will see dated 3/11. 2025, my lord. Thereafter, we passed this order, that is SL at page 53.
6/11.
6/11, my lord. And we made a, my lord, joint verification also that, my lord, finds at page 63. After this order, my lord, that order was assailed. This, the last, that notice was assailed, my lord, that order came to be passed. Then we did this, my lord. Page 63, my lord, it's very relevant, my lord. The petitioners, namely Rohibul Hussain, Mallika Khatun, and Insaf Ali, these three petitioners, my lord, were among those served with the eviction notices under section 24.
You're reading from
Page 63, my lord, my affidavit.
63. Yes. Hmm.
Pursuant to the earlier order passed by your lordships, my lord,
Hmm.
these petitioners, background, I'll go to background, my lord. The petitioners, namely Robiul Hussain, Mallika Khatun, and Insaf Ali, were among those served with eviction notices under section 24 and 25 of the Assam Forest Regulations 1891 for encroachment inside the notified boundary of the Dohikata Reserve Forest, notified by government notification dated 1973. Their representations were duly received and examined along with the revenue officials during the joint verification conducted on 2nd and 3rd November 2025. During this verification, the boundaries of Dohikata Reserve Forest were correlated with geo coordinates based on the above notification and physical boundary markers. The land claimed by the petitioners under Dohikata Luptachar was found to lie within the notified boundary of Dohikata Reserve Forest as per the joint demarcation. The petitioners could not produce any valid patta record or evidence of lawful possession over government land outside the RF area. Based on the above, the speaking order dated 6/11 was issued by this office rejecting their claim and directing them to vacate the encroached forest land within the stipulated period. In compliance with the Honorable Court's verbal observation conveyed through your letter, the relevant notification described in Dohikata Reserve Forest was revisited. It was found that the Gwalpara Matia PWD road mentioned therein passes through the Dohikata Reserve Forest, and the area north of the said PWD road falls in the notified boundary of Dohikata RF. This exercise was done while this petition was pending. Hence, the claim of the petitioner that their land lies beyond RF boundary and outside the forest area is actually incorrect. So if my lord now perishes page 63, or I can give the my lord colored copy.
65.
65, my lord.
Oh,
It's a colored copy, my lord.
this is a colored copy.
Yes, yes. So my lord will see from the top of the left-hand side, it is written Dohikata RF. This is the road.
PWD road.
This is the PWD road, my lord. And this yellow line, my lord, along with the road, is the forest boundary. Initially, my lord, runs with the road, along with the road, my lord. Then it goes north. Again north. Then it comes to south, my lord. My lord, you see the pins. These are the petitioner's area. Insaf Ali, Mallika Khatun, Robiul Hussain. Directly inside, my lord, the forest. They say this road is the boundary. It's not the road is not the boundary. This is the boundary, my lord. That yellow mark, my lord. They're inside forest. So they have no claim, my lord. In fact, my lord, one more interesting fact, my lord. After that order, my lord, the first writ petition, they contended that they are having title over the land. So this honorable court directed us to go for a joint verification. We did the joint verification, and it was found, my lord, the petitioner number 1 to 6 of that writ petition, 59, were holding valid patta, my lord. We have excluded them. It's not that, my lord, we are mechanically doing it. We have verified, my lord. It was found that petition number 1 to 6 in that writ petition were holding patta land, my lord. What they have done actually, my lord, in the earlier writ petition, these first 6 writ petitions are the face, my lord, because they are holding valid patta. Rest have no document, my lord. When we made the exercise, we found this, my lord. Will kindly peruse page 66, my lord. Page 66 is a speaking order. The speaking order in respect of the petitioner was resulted in, my lord, rejection, my lord. This is an order, my lord. Paragraph 3, my lord, says, and whereas a joint survey of encroachment inside Dohikata Reserve Forest was conducted by the officials of Forest Department and Revenue Department so as to demarcate the encroached areas within Dohikata Reserve Forest, identify specific blocks for taking up eviction, record ambiguous land parcels where patta and other rights are claimed, and also to exclude areas currently under consideration of the right settlement under Forest Rights Act 2006. Such joint verification was based on boundary coordinates of Dohikata Reserve Forest and corresponding KML image and all other relevant records. And whereas Dohikata Reserve Forest was notified as a reserve forest by government notification number so and so dated 5473 under the provisions of the Assam Forest Regulation, And whereas detailed verification, evaluation of the joint report dated 26/9/2025 and dated 3/11/25 and other relevant record, it has clearly emerged that the area under occupation of the noticee wholly lies within the notified boundary of Dohikota Reserve Forest, and therefore no valid patta rights could be issued or accorded in such enclosed occupied land of Dohikota Reserve Forest. Accordingly, the matter has been communicated to the District Commissioner Goalpara, seeking an inquiry to the circumstances under which patta were granted inside the area of reserve forest, which is impermissible under the Assam Forest
This is
Regulations.
in respect of people who have got pattas.
Yes, though they were, my lord, there are 6 persons, my lord, who were read petitioner. If my lord peruses the annexer 1 for a moment, my lord.
Mm. All right. Now,
And-
what is the reply?
Well, actually, effectively, there is no reply, my lord. If my lord peruses page 45, my lord,
Yes.
these petitioners number 1 to 6 were found to having patta. That's why they have been excluded from the eviction, my lord.
They were having patta within the forest area.
Within the forest. That for that, my lord, we are causing an inquiry. But since they are having a patta, my lord,
Mm.
so my lord, we are not evicting them now. But these petitioners are without that, and apparently, my lord, admittedly, even the map also shows, my lord, that they are inside forest. But page 45, my lord peruses, it is Akbar Ali,
Mm.
and if it is
Where is the order of the court again?
order of the court, my lord, relevant part, my lord, finds at page 52 to cause a joint verification with the revenue, my lord. In this writ petition, there were 59 writ petitioners, including the present 3 writ petitioners, my lord. So these present writ petitioners, my lord, they are having no document to show but claim title inside the forest, my lord. Their only contention was that their land falls beyond the boundary of the forest, which is incorrect, my lord. That is, my lord, that transpires from the notice itself, sorry, my lord, map itself.
Where will they be relocated? Assuming they are evicted.
Well, what we have done, my lord, so far, my lord, we evict them. If they want, my lord, we can provide temporary shelter. In most of the cases, my lord,
Temporary
they've got-
shelter where?
that will be decided by the revenue authorities, my lord, because inside forest they cannot do stay. And my lord will kindly appreciate one thing, my lord. In most of the cases we have seen, my lord, in respect of Goalpara, my lord, their actual village is in Matia in Borpeta, my lord. In respect of Goalpara, I'm sorry, my lord, Golaghat, we have seen their original residence of Rupohi and Dhing, my lord. So it's not that they are homeless, my lord. They have migrated to this forest, my lord.
Yes.
My lordship, I will kindly produce the notification, my lordship, on 5/4/19.
Page number?
73, the page number 19, my lordship.
Yes.
This is the notification, my lordship, of the forest area which was issued on 5th April 1973, my lordship.
Mm.
Here it is specifically written east, south, boundary has been demarcated, my lordship. So my contention is in the writ petition that our village falls outside of this demarcation, my lordship. Now come to my lordship, letter dated 4/8/1987. 4/8/1987, page 24.
Mm. Yes.
My lordship. This is the letter issued by Circle Officer Matia Revenue Circle, my lordship. Married, madam. With due respect, in connection with the above mentioned subject, I have the honor to state that as per the petition submitted by Sri Osman Sheikh, resident of Bhatiapada village under Matia Circle, he has alleged that Forest Department has encroached upon illegible leases of land under DAG number 63 and illegible leases of land under DAG number 78 to tell that cannot be read, my lordship, individual lectures. However, as per the field investigation report and Mandal field staff, it has been found that the forest department has not encroached upon the such and such areas of land under DAG number 63, but out of such and such areas of under DAG number 78, an area measuring such and such lessors has been occupied by the forest department.
Hmm.
By planting various trees and fencing the area, fencing the area with tar, bamboo fencing. Therefore, for your kind perusal and necessary action, the original petition, the Mondal's report, the trace map and the cheetah copy are hereby forwarded. There has been a dispute, my lordship, whether the land is a forest land or a patta land or is a revenue land.
So how is a writ court going to decide?
My lordship.
On what?
I have
Serious.
stated in my reply, my lordship. When I have annexed some of the documents, these are government documents, this itself shows that my lordship, the area is does not come under forest, my lordship.
What do you say about the map?
Map, my lordship, my lordship. I have annexed the map, my lordship, page 76, my lordship, maybe 96 may be seen, my lordship. They are not relying on the map which has been uploaded by the Revenue and Register Management Department, my lordship. Forest Department has given a map. Who made that? We don't know, but this has been uploaded in the by the Department of Revenue and Register Management, my lordship. It itself says that, my lordship, that the village, my lordship, it comes outside the forest area, my lordship. And if they don't want to accept their own map, my lordship, then
Where is your land here?
my lordship.
96.
When I have annexed, my lordship, the one document, my lordship, it's an order of the
Where is the land? Where is your land
my lordship
in the map?
map. Dag number 422 and dag number 8889 and dag number 50, my lordship. In the map, it is shown. Dag number.
88, 89. Then
Yes, ma'am. Dag number 8889 and dag number 422 and dag number 50.
50.
50, my lordship. And in the map uploaded by the Revenue and Disaster Management, my lordship, they have stated Forest Department land, my lord, they doesn't have dag, my lordship, dag number, patta number, my lordship.
What is the stand of the revenue? Revenue?
In forest land, my lordship, only pillar number they have. And I have a next one order, my lordship, of the circle officer, my lordship, page 98 may be seen, my lordship. Page 98.
Where are your land documents?
My lord, I am not disputing to the fact that this is a government land, my lordship. I am landless person, my lordship.
Then where is the question of giving the DAG numbers?
My lord, Chitta is there, my lordship.
It's 96. You are showing that these are the DAG numbers.
Yeah, Chitta, I have a Chitta also, my lordship.
What is 96?
96, my lordship, during my predecessors in interest, my lordship, there was a dispute, my lordship, and regarding that, my lordship,
Now, if it
one
is a
order has been
government
passed.
land, where is the question of giving DAG numbers? Unless it is settled. Unless it is settled,
Yes, ma'am. Dag number is there and Chitta is there, my lordship.
how can there be a DAG number in a government land?
But the register management, revenue register management document, there also everything has been mentioned, my lordship.
What documents do you hold in respect of that land?
My lordship, Chitta, my lordship, I am having, my lordship.
Page number?
Page number 95 and page number 93, my lordship. And also page number 91, page number 89 and from 88 to my lordship, these are Chitta, my lordship, from Chitta for surveyed villages, my lordship.
Where is the joint verification report?
Yes, ma'am. Right, sir, আমার reply এখন করবো।
Next, sir, page 98 and 99 very much relevant, my lordship. My lordship. Page 88 and 98 and 99 of my affidavit in reply. My lordship.
Page 311 report number, I have not annex, but it is mentioned.
Till date, my lordship, it has been recorded as revenue land under the revenue and register management department.
Seems no. Wait, when did I back on it?
Who are the parties here in 98?
My lordship, these are private parties, my lordship, and they are also relying on Google Map, my lordship.
Who has enclosed this document at page 98?
My lordship, this is a my lordship, this is the petitioner, my lordship. One, my lordship.
So where do you find that it relates to the petitioner?
My lordship, is the father of petitioner number.
On what basis are you making all these statements? This document has to include show the name in respect of whom this order is passed.
My lordship, in my writ petition, it is clearly stated my father, my lordship, Akbar Ali, my lordship.
You know, a mere statement will not do. You have managed to get a copy of this order passed by the district magistrate of a proceeding. You have only enclosed the part of it. Who's for the revenue? This appears to be a conflict between forest and revenue.
That because of that, this argument was made in the first round of litigation. Thereafter, that joint verification was made. Joint verification report by, though I have not annexed, it is clearly mentioned in the speaking order. There are two joint verifications were made.
And who were present in the joint verification?
District revenue authorities and the DFO office.
Brought it on record.
Yes, my lord will kindly see, my lord, page 56. This was, my lord, after the first round of litigation, my lord.
Yes.
Page 56, last paragraph, my lord, we'll see. And whereas upon detailed evaluation and consideration of the representation submitted by Sri Mallika Khatun and upon consideration of joint verification report dated 26/9/2025 and 3/11/25 and relevant forest record, it has been clearly established. This was done in terms of, my lord, the earlier order. Earlier order, there was a direction to cause joint verification.
Now, there's another map which is enclosed at page 96.
Yes, my lord, if we compare that map with the forest map, my lord, we'll see. 96 as well.
96 and 97, my lord.
Even assuming that this land is within the forest area,
My lord.
then how can the revenue, this is uploaded by the revenue department.
Yes, my lord.
How can the revenue indicate these plot numbers or DUG numbers?
True, that is why, my lord, that joint verification was made, my lord.
So after that, what has happened?
After that, my lord, we have evicted everyone, my lord, from this area.
No, but this has to be corrected also.
That will be corrected, definitely that will be corrected. But it's a map prior to, my lord, this joint verification exercise was conducted, prior to this eviction notice. And if we, my lord, see, my lord, will see, not the entire area is, my lord, forest, because this forest map, my lord, goes up and again takes a right turn and comes down, my lord. This is the only part, my lord. This is the forest area.
What is the stand of the revenue, Mr. Borpujari?
As such, is not a party department here.
Huh?
Only the district commissioner and circle officer are party respondents.
So who represents them?
My learned colleague will be representing.
My lord will do one thing, my lord.
Respondent number 5.
My lord will do one thing, my lord.
We will request your assistance. There's no difficulty there.
Absolutely.
May I suggest, my lord? My lord will post it tomorrow, my lord. I will bring the joint verification map and any instruction from the DC, my lord.
All right.
These two joint verification reports I will produce, my lord.
My lord, original map also may be called from my lord.
of the forest, my lord.
From the revenue side, revenue, we want to know whether the land in which they are claimed to be in occupation, whether it is under the revenue area or the forest area. Forest has made a joint verification, it's given a map saying that this is within forest area. 4, 5 or 6 persons who have been settled with documents, their cases are being taken up with the revenue. Rest of the parties have been evicted. So therefore, what is the stand of the revenue? Because in the map of page 65, if you look into page 65, map is the map of the forest.
Yeah.
And page 96 is a map which appears to be uploaded by the revenue department. Both appear to be in conflict, pertaining to the same area.
These are uploaded, my lord, these Bhunaksa maps, these are not conclusive matter. These are, my lord, prepared on the basis of, my lord, geo positioning. Now, after the joint verification has been done, my lord, with all respect, on site. Now, there from the joint verification report, my lord, the actual picture will come.
So you
It
get
might
the,
quite so happen, my lord.
get the report?
Well, that I will take, my lord. I will take all the instructions from the DC. my lord.
Report will cleanse the issue.
All right. Tomorrow?
Tomorrow.
After hearing the counsel of the parties at some length, it is, the court is of the view that the joint verification report, which was conducted by the revenue and the forest department in respect of the land stated to be under occupation of the petitioner, would be necessary to resolve the dispute presented before this court. Let these records containing the joint verification report and other relevant documents, if any, be placed before the court tomorrow by the forest department. Mr. Loskar for petitioner, Mr. Goswami for forest, Mr. Das for state, and Mr. R. Borpujari for the revenue department, although revenue is not a party. The present as a part is arrayed as a party respondent at the request of the court. Mr. Borpujari is assisting the court.
So,
Original map, my lordship. Also because,
Whatever comes, let us see.
I'll oblige me.
But here, my lord, the road was being constructed, my lord, and we say, my lord, that will encroach upon Patta land.
Oh,
Accordingly, my lord,
When the instruction has been received, my lord, it says, my lord, the road is over the said Dag number, my lord. And it
State
has,
Dag number.
yes, my lord, and it has been continued since 1960s post settlement, my lord. So if your lordship asks me to bring on affidavit, it will be better, my lord.
Oh, why should we ask you? If you want to bring, you bring it.
Yes, my lord.
our case is, my lord, it is further eroded into our land. We are saying that this road was constructed over our land. Now they are, my lord, trying to further encroach our land, my lord.
All right, heard Mr. M. Dattal and counsel for the petition. Mr. Das appearing for the state. He submits that he has received his instructions. He'd like to bring it on by way of an affidavit. Accordingly, let notice issue returnable 2 weeks. Mr. R. Borpujari appears for respondent number 1. M. Das for
But 4 and 6, my lord.
the respondent number 4 and 6 and Das. 4 and 6. And M. Das for
4,
2, 3,
5.
5. Steps on respondent 7 by registered post within 3 working days. The respondents may complete their instructions and file necessary affidavit. Extra copies, if not already furnished, be furnished within 3 days.
Interim order.
Interim order passed early will continue.
Diploma.
After 2 weeks, my lord.
Notice.
Motion, my lord. Notice me.
Heard counsel for parties, we should notice returnable 4 weeks. steps on the respondents by registered post within 1 week. Matter will be listed thereafter.
Same respondent in the next item also. Item 4.
Same respondents.
Same order.
Item 4, same order.
Same order. Outline.
Notice. Heard yesterday as Kotoki Council Office issued notice. Returnable 4 weeks, steps on the respondents by sole respondent by registered post. They registered post within 1 week from today.
6 also same.
6 also similar, same order.
7. Wait, please, your lordship. My lord, 7, 8, 9 are the same, my lord, against the same
Yeah.
respondents. My lord, the operative portions in 7, my lord, quantum case number 19, my lord. They were directed to recalculate the land compensation award in accordance with the new act. That is, the direction is at page 22.
But heard Council for Parties issued notice. Returnable 4 weeks, steps on the respondents by registered
postman
within 1 week from today.
7 and 8 are the same, my lord.
7 and 8, same order.
Mine. Deeply applied. 7, 8, 9.
7, 8, 9.
Yes, deeply applied.
Yes.
Lordship, here in this case, freezing of my account without issuing any single notice.
We had passed orders keeping the lien over the said disputed amount.
Yes, sir.
Rest, what is the amount in dispute?
252. 252, lordship.
250?
No,
252
yes, lordship.
only. Oh.
Lordship, we have freezed the account as per the acknowledgement of cyber fraud, lordship.
Wait. আমি এনেকুৱা order দিছো no bank freeze কৰে but keeping the amount in dispute lien bank being the lien and balance you should allow to operate the account. Do you have a copy of that order we had passed earlier? We are closing the matter, directing the bank to, we will have his lien over, say, the disputed amount rounded off to rupees 300, let us say.
Lordship.
And the rest, you allow the bank to operate,
Lordship.
the customer to operate the bank account.
Lordship.
This poll, no? It was the last one. Signing.
Much obliged, lordship.
Items 11 and 12.
Please, your lordship. Lordship, in item numbers 11 and 12, we'll be filing an affidavit during the course of the day. And in item number 13, we'll be filing it by tomorrow or day after tomorrow. These are all connected, your lordship.
Then fifth,
The 5th, your lordship.
or some days later,
Some dates later, my lord, after 9th, my lord.
12th,
My lord.
12th February. List these matters again on 12th February.
Lordship, can it be on 5th? My senior has asked me to fix.
No, my
it.
lord, we.
They would like to file a reply,
My lord,
reminder.
that's why.
Because
Okay.
there's
You have to file your affidavit first.
My lord.
The Council for the Forest
forest.
My-
lordship.
submits that in item number 7.
11 and 12.
11 and 12.
11 and 12, you're filing an affidavit today.
Today.
And in item
13,
13, you're filing it tomorrow.
tomorrow.
All right. Under such circumstances, let the matters be listed on 12th February, enabling the petitioners to also file rejoinder affidavit, if so advised in the meantime.
Mal. There is an interim orders, my lord, that may
Where?
come. In all the cases, my lord.
It's not here,
No,
is
sir.
it?
It was there, my lord.
Okay.
Mal.
Interim orders passed earlier will continue till the next date. Next, Mr. R. Borduzari for revenue. You are filing something?
Their affidavit will do.
All right.
I'm so obliged.
Obliged, my lord. 14 plus.
I can 14.
Or another. Oh. Lord, this has already been, my lord, is similar. My lordship has disposed of one matter yesterday. My lord.
Yesterday, my lord, it is same matter, but only my instruction has been not, formal instruction has not been received. So let it be after 2 days, my lord.
Friday?
In the meantime, I can
Give us a
receive.
copy of that order.
My lord, it can be disposed of, my lord. There.
No, because in that order we had recorded
Yes,
that
yes,
he
yes.
had
There-
obtained
there
instructions and
yes,
placed
yes.
it.
Yes, yes,
If you can get it instructions on Friday, we'll close.
yes, 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 my Friday, my lord.
Friday?
But my lord, the apprehending date on 30th. Lord, they may demolish, that's the problem, my lord.
Get it tomorrow?
By tomorrow, my lord.
Please, this matter tomorrow,
One.
as requested by Mr. N. Das, Government Council, Mr. A.R. VIPs for the petitioner.
Supply question. Oh, এইকেইটা কৈ দিয়া একেলগে supply কেইটা।
15.
GST cancellation matter, please.
Appeal dismissed.
Dismiss matter.
Then
This was similar order matter for restoring.
where is that order?
Sorry, matter.
Who's for GST?
State GST is there, Mr. Beach.
State GST. Mr. Borpuzari, you are appearing for GST also. Please inform the council.
Yes. If Bikram Chaudhary appears, my lord, I will inform him.
Please inform.
And
Matter.
No, but this is, you've given me a part of the order.
I think.
The order to regulate.
It is there, matter. Yes. I'm sorry, my lord, by mistake.
This is not a matter where an appeal was preferred.
My lord,
There were other orders passed where
ma'am.
it was passed in connection where appeals were preferred and rejected. Do you have that copy?
That copy, my lord, I actually. Yes, no, one, no, it's not there. I will, lots of take about 2 PM, I can find out, my it is there.
2 PM, Mr. Chaudhary, you must be having.
No, lots of.
Only factual difference is appeal, my lord,
Now at 2 PM, you will find out.
my lord.
Our orders are available. GST registration cancelled, appeal filed, appeal dismissed for limitation, and also we have allowed direction with the sign over. The chart for no Google Docs. Yes,
16.
Google Drive.
It is also GST cancellation, my lord. Here,
Same order.
Same order, appeal was dismissed, my lord here.
All these are appeal matters.
Yes, madam. Only one matter, item number 17, in item 17, there was no appeal, madam.
You will call up all these matters at 2 PM.
My lord.
Item number 15 to 18
My lord.
at 2 PM.
My lord. Yes, yes, one second. And 30 also, my lord.
And 30 also.
My lord. Much obliged, sir.
এবার দুপুরে সাইন করবেন গুগল ড্রাইভ।
Item 19.
Where is the petitioner in person? Why have you not released the bills?
Lordship.
Who's for the income tax? This is income tax matter. At 2 PM, no? Please call for the.
19 Lordship. I am
Yes.
appealing. Lordship, it's very unfortunate I have to appear before this honorable court seeking my legitimate legal fees, Lordship. These are kept in hold for the last about 2 years, Lordship. Number of occasions I have reminded them, mails, phone
Where
calls,
is your
everything,
counterpart?
Lordship.
You get hold of your counterpart, income tax.
Lordship,
We will call it up at 2 PM.
yes, Lordship.
You get hold of your
Very
counterpart.
small amounts, only 79,000 something, 76,000 something, Lordship. It's small
Is
amount.
there any admission that this amount is to be paid?
Lordship, it is admitted theft, Lordship. They have, earlier I have contacted, they are under process, but for about 1.5 year, it is, now they are saying that they are not traceable. Or 2 occasions, Lordship. Not only first occasion, the second occasion also I have sent. The same bills, Lordship.
So we scroll for you income tax at 2 PM. We'll call up at 2 PM.
Highly obliged.
21 is my lord, it's a civil bench 4 matter, my lord.
Civil 4,
4 my lord.
non-payment.
Non-payment of contractual bill. My lord.
Why is it here? It is marked as civil bench 5. Here, 4 minutes. Huh? Civil bench 4. Hold on. We'll verify and if required, we'll send it before court. You find out from the court master at 2 PM.
That's, obviously.
22.
May I please your Lordship? The petitioners are the IMFL on-shop license holders, and they are registered under the Assam Act since the month of July 2025. When they received the notice, official notice from the respondent authority number 4 on 10/7/2025, they get registered themselves. Thereafter, they have circulated some series of notices in which they are asked to pay the VAT since the 1st April 2024 till 31/10/2025. So they have jointly made a representation before the respondent authority number 4 to exempt their tax since 1st April 2024 and allow them to pay the tax since the day of their registration, as they did not collect their taxes from the customers before that. And when they registered themselves, they started to collect the taxes. So they want to pay from since the month of July 2025, Lordship.
You are now registered as a dealer.
Yes, yes.
Your dispute is you want to pay it from which year, which period?
Since July 2025, as they registered themselves on that day.
Okay. And your entitlement, you're required to pay.
Since 1st April 2024, from the previous year, Lordship.
So the liability will be dependent not on the day you get registered.
Lordship.
Liability will be dependent on the day the incidence of taxation occurs.
Lordship, they were not aware about the.
You may not be aware,
Yes,
but your liability to pay, if it is from a particular date,
yes, Lordship.
you are required to pay taxes from that date.
From the date of registration, they want to pay.
No. It's not up to you.
Lordship.
It is not a matter of choice.
Yes, Lordship.
This is a state revenue. If you have to pay from X date, you have to pay from X date. You can't say that, no, I'll pay from X plus 15 days.
But they have not collected the taxes from the
You may not
customers.
have collected, you paid from your own kitty.
Because this is the taxes on sale, Lordship.
If you have not collected, is not a ground not to pay.
But the
Unless you say that prior to the date of registration, there was no incidence of tax.
Yes, Lordship.
Therefore,
They were, the respondent authority never issued any notification regarding the no payment of any tax, Lordship. Just on 10/7/2025, they have issued notification that is not 42, Lordship. Kindly peruse the notification. Page number 42.
notice for registration.
Yes, Lordship. In which they have mentioned that whereas section 21(1) of the Assam Value-Added Tax Act 2003 clearly states that no dealer shall, while being liable to pay tax, carry on business as a dealer unless he has been registered and possesses a valid certificate of registration. It also states that a dealer liable to pay tax shall apply for registration with 30 days from the date on which he first become liable to pay such tax. Whereas as per government notification number so and so, and amendment of section 10 had been done by a substitution of subsection 1A, which now reads as, notwithstanding anything contained in this act, the retail on license holder for portable liquor mentioned in the fourth schedule, except country spirit, shall pay output tax on sale made by him at the rate of 6% without any set off of the tax paid on the purchase made from bonded warehouse in the state, subject to the condition that such portable liquor are purchased locally from bonded warehouse of the state. Whereas the undersigned is in possession of sufficient information that clearly proves your liability under section 21(1) of Assam Value-Added Tax Act and your failure under section 21 read with rule 13(1) of the AVAT Act 2003 to apply for the same to the prescribed authority within the stipulated time.
Right. What do you say? Excise?
After that, they registered themselves.
Lordship, here the excise has nothing to exactly do with it because here the notice have been sent by the tax department.
Yes, tax. Did you send the notice separately?
Lordship, that information I will have to take.
I heard Learned Council for Parties issued notice
Lordship, interim
Very-
prayer may be given.
after 4 weeks. Mr. R.R. Gogoi appears on behalf of respondent 1, 6, 8. Mr. B. Chaudhary for respondent 2, 3, 4, 5. And Mr. N. Das for 7. Since the respondents are represented, notices are waived, extra copies be furnished within a period of 1 week from today. The grievances of the petitioners are that they were not aware that any duty or any taxes under the Assam VAT Act
Yes.
was required to be paid on the sale of potable alcohol or liquor by the petitioners. Stop, these petitioners own the retail
Online.
on shops. Stop. It is only on July 19th, 2025, that a notice was issued to each of the petitioners by the Superintendent of Taxes, calling upon the petitioners to get themselves registered under the Assam VAT Act and to pay VAT at the rate of 6% on the sales made by them. Stop. The counsel for the petitioner submits that it is only after this notification that they came to be aware of the fact that they are required to get themselves registered as dealers under the Assam VAT Act and rules and required to pay tax of 6% on the sales made. Stop. The grievance of the petitioners are that the demand of tax is being made with effect from 1/4/2024.
Yes.
Stop. It is the submission that during that period, the petitioners were not even aware that they were required to pay taxes on the sales made, and therefore no collection was made in respect of, on account of VAT on the sales made during that period. Stop. It is only after 19th of July 2025 that they registered themselves as dealers under
Lordship,
the VAT Act.
10/7.
Huh?
After 10/7/2025.
After 10/7. And after that, you have collected the tax.
Yes.
They've started collecting VAT at the rate of 6% on the sales made by them. Stop. Under such circumstances, the counsel for the petitioner submits that the authorities did not issue the relevant notification calling upon the petitioners to get themselves registered under VAT prior to 19/7/2025. Being agreed, the present writ petition is in file. But having heard the counsel for parties, since notice has been issued, matter will be listed after the returnable date. Meanwhile, in pursuance to the notices issued, no coercive action be undertaken against the petitioner till the next returnable date. List again on 27th of February.
Lordship, at least let them pay the current VAT of this year, Lordship.
The petitioners, however, will continue to pay the VAT collected from the sales, from the current sales. And such VAT collected will be continued to be paid by the petitioner.
Hello, guys.
You serve extra copies.
Item 23.
A lot of the petitioner land were required for the project of thermal power project. Malot on 31/10/2025, the petitioner filed an application under section 64 to enhance the award and or refer the matter before the competent authority matter. And as per proviso.
Get instructions, what is the status
Yes,
of the application?
Page 37.
That we may take it, my lord, but as per my lord, provision of section 64, here is a case, my lord, where he is not accepting the quantum of my lord compensation awarded. Now he is trying to get an enhancement. He has made an application before the district commissioner. His case is that my lord, district commissioner has failed to attend his application. Now there is a provision, my lord, if the district commissioner fails, he may directly go to the authority, which he has not.
Which authority?
My lord, the determining authority. The land acquisition authority, my lord, that is the court of the district does.
But get the instructions as to what has happened to the application. Why has it not been taken up?
Yes.
Grievance of the petitioner is that his application for enhancement of compensation for land has not, although filed before the district commissioner, has not been taken up for consideration. Stop. Mr. You'll get it. Ms. Lady will, government advocate will obtain required instructions in the matter and place it before the court. Mr. R. Pujari appears for the Revenue Department. Although notices are not issued, extra copies be furnished within 2 working days to enable them to obtain instructions. List again on 13th
Yes.
February.
Actually, another matter is fixed on 11. My lord.
11th. Can you
Yes.
get it by 11th?
Let it be 13th, my lord, if we, by.
What difference does it make? No.
Well, individual consideration will be made. Yes, to get individual conservation has to
Yes,
be
yes,
made,
yes.
not analogous matters.
Obliged.
24.
Yes.
May I please your lordship? My lord,
Large
petitioner was
My
entrusted.
lord, appears to be at bench for my lord.
Is it?
Yes, but it is a non-payment of bills.
Documentary features has been made, my lord, then he's not getting his bills, my lord.
Bench
Non-payment
Let
of
it come on
dues
day
by the
after then,
government.
that is.
It is a matter pertains to my lord, non-payment of dues by the government, by the state authorities on account of my lord making a film, documentary film. it
So
is
these are bench 4,
Bench
non
bench 4, not this bench, my lord.
Oh.
That I don't know, my lord.
Oh. He will, court master will check up if it is bench 4, You'll get it listed by Friday
Friday, my
Otherwise-
lord.
or on any other date that you want.
Let it be there.
It is submitted at the bar that this matter is
26.
only listed because it's right. It pertains to a bench four matter, civil bench 4. Registry to verify the same and list it before bench 4
30, my lord.
on 30. 30. পুরোনো ক্যালেন্ডার লোক আছে নাকি শিশর এখন গুছাই 26 কোটি এখন পুরোনো আছে নাকি ইউনো সাবটি Yes.
Lordship, basically here we have agreed for acquisition of the land, your lordship, construction of the land over the crossing the Patta land of the present petitioner without acquisition of the land of the petitioner as per law, your lordship. A construction of bridge under bridge number 11 on Durahati Bazar to Baladova Hariali Road via Sir Durahati LP School was constructed, your lordship. Connecting over enclosing the land of the present petitioners, which is the Patta land covering 5 bigger 2 katha land. And there is no any acquisition that has been notice was issued to the present petitioners, nor any compensation has been paid, your lordship. The petitioner has approached to the authority by ventilating his given by submitting representation. That was also not been acted upon, your lordship, but construction is still going on.
Yes,
This may go, my lord. We need to file
I
affidavit.
heard council for parties issue notice returning in 4 weeks. So it appears on
I'm
behalf
3 and 4.
Huh?
I am for 3 and
Appears for 3 and 4. Mr. Arbor Fuzari for 1. Mr. B. Chaudhary for respondent 2.
5 and 6.
2, 5 and 6. Since the respondents are represented, notices are waived, extra copies will be furnished within a period of 3 working days. The respondents will complete their instructions and file necessary affidavit, if so advised. Yes.
So far the land which was been, that has been utilized by that part may be.
Let them
rested.
get the instructions.
Yes.
May I please allow? Here in the petitioner, he was disqualified and removed from the post of Gaon Panchayat member, your lord. And in the last Panchayat election, the petitioner was elected and thereafter he was discharging her function, your lordship.
We'll have to issue notice here.
But the fact is that, your lordship, nothing, your lordship, no such inquiry there was, and in a similar. Lordship, a coordinated bench of this honorable court, your lordship, has passed an interim order in. And on that issue, if election petition is also pending, your lordship.
Then?
Election petition is also pending.
Then why are you challenging it here?
No, this order passed by the deputy commissioner, your lordship, during pendency of that petition.
Election petition filed by whom?
Filed by the respondent number 7.
7.
Yes. But I have annexed the birth certificate of the petitioner, marriage certificate of the petitioner, your lordship. These all are shown.
Yeah, we'll issue notice today. Let them
Yes.
get instructions.
But my case is
Affidavit
that,
is
your lordship,
required.
that marriage certificate as well as the birth certificate of the petitioner, I have annexed here. But these 2 documents shows that he was major at the time of marriage.
Let them
Lordship,
get their
we are here
instructions.
after having the affidavit, my lord.
Let them have their instructions properly.
But I'm saying, your lordship, both this matter and
No,
that
what
matter is
interim orders
required
you
is-
want? What interim orders?
I'm for staying this order.
Staying which order?
Matters cannot be squarely
Staying
covered,
with
my lord.
just-
Facts has to be
Page number?
definitely
Case
different.
number 5, your lordship.
Huh?
Sorry, 31, your lordship.
31.
Yes. By this order, the petitioner, he has been declared disqualified and removed, your lordship.
So this will amount to giving you the final relief. If I have to stay this,
But in that case, your lordship, that order passed by the
this case is
deputy.
not before us. You are praying, you are challenging this order where you have been disqualified on the basis of some notification. Now, if this order is stayed, then you will continue to be a member.
Yes, yes.
Then that is the final relief you are asking for.
My contention is that, your lordship, before passing this order, your lordship, no such hearing there was.
We will consider
I
this
have a
issue.
bona fide case, your lordship. I have
As
addressed the
a counsel
documents.
for parties, issue notice returnable 4 weeks.
Obliged.
MS Sonso and
I am for only deputy commissioner, my lord.
appears for respondent number. There is no deputy commissioner here.
No, district commissioner,
District-
Dhubri, Assam, respondent number
For
4.
four.
Others are represented by Panchayat, my lord. PNRD.
Who is for PNRD?
As doctor's name may be shown, my lord. I
Mr.
will
Hayes,
inform.
Doctor appears for respondents 1, 2, 3, 5 and 6. Since the respondents 1 to 6 are represented, notices of waived, extra copies be furnished within a period of 1 week from today. Steps of respondent 7 by speed post within 1 week from today.
3 is
Should notice-
represented by SC Election Commission, my lord, R. Dubey.
Mr. R. Dubey for respondent 3. Registry will reflect the names of all counsel in the first
It is already reflected, my lord. Yes.
Issue notice on the interim prayer, returnable again on 27th of February. Meanwhile, the post of GP member for ward number 9 of Jogir Mahal Gaon Panchayat. Is there a scope for by-election?
It's difficult to submit right now, my lord, because I'll try to file affidavit by the next date, my lord, on urgency basis. That much I can assure.
No steps will be taken by the state to fill up the post of GP member,
Without the
ward
leave,
number 9 of Jogirmal Gaon Panchayat, without leave of the court.
lordship,
That much we can give you.
lordship.
But I'm saying, your lordship, interim may be on the returnable date, your lordship.
We are giving a notice.
Notice is already in time.
If you don't want this interim, we'll not include it.
Obliged.
Lordship, this matter will be kindly absorbed for the time being. Kane Soguri, sir, will be appearing. He's in court number 1, attending.
All right. Then we.
Obliged.
Please, your lordship.
Worship, we are before this, petitioner is before this honorable court because of an action taken by the circle officers, this board, whereby in spite of, because there are notices after notices with regard to demarcation of a plot of land is being issued. Now, that plot of land was a subject matter of a title suit, where it was partly decreed in favor of the petitioner and partly against the respondent number 4 out here. Now, both the parties are now before this honorable court in first appeal, which is pending. And the respondent number 4 has initiated a demarcation case with regard to the same plot of land. We have intimated on receipt of the notice, we have intimated the circle officer about the pendency of the case and that the subject matter is sub judice. Now, in spite of that, notices are being issued to demarcate the land when the matter itself is in dispute, because I am a Khetyan holder. My predecessor was the Khetyan holder of the plot of land under the father of the respondent number 4. And he is now substituted after the demise of the respondent number 4 father. He is now substituted in both the first appeal. He is a party in the proceeding before this honorable court. And in spite of
What is your prayer here? What do you want?
we want a stay of the proceeding before the circle officer, because till the matter is decided, finally decided, if the boundary
You
demarcation is
file
done.
your necessary applications before the circle officer.
File 3 objections.
Bring it to the notice that matters are pending.
We have given them
3 objections.
3 occasions, they have issued notice. We have given them the details about the pendency, but still he is insisting upon physical verification and demarcation.
What is the, who is the decree holder?
Decree holder is partly it is given in our favor that I am a Katiyan holder under them. I'm the temporary settlement, I am a Katiyan holder, and partly against the defendant, respondent number 4. Both of them has filed counter appeal before this honorable court
There is
against the
no,
same judgment.
there is no stay.
There is no stay.
Hmm.
There is no stay in the sense both have appealed against that judgment because partly in my favor it has been given that I am a tenant
Now,
under them.
The circle officer, what is the difficulty if the circle officer proceeds to demarcate?
He
in
is
terms
making
of the-
demarcation on the plot of land which is in my possession
Hmm.
and which the trial court has also admitted that I am a tenant under the Temporary Settlement Act and I have a valid Katiyan with respect to that. Now, when both, and he are challenged, they have challenged that particular finding of the trial court saying that this finding that the Katiyan was a proper Katiyan is challenged before this honorable court in a process.
We should file applications before the appellate court that during pendency of the appeal, this.
No, I have before the appellate court because circle officer cannot be stayed with regard to that because this is a totally different aspect, Your Lordship.
Yes, who's for the respondent, Mr.
If I am appearing.
Verma?
Yes, Lordship, I am on the part of the circle officer in a demarcation proceeding, he can only show as per the existing record that this is the plot of land. We cannot hand over the position. It is the only on the domain of the civil court, Lordship.
No, but
In addition to that,
He's aware that there is a litigation pending and.
Lordship, for some reasons, there are 3 or 4 notices were served upon them, but no hearing took place. Ultimately, page 155A, that is the last notice, 155A, 3rd of December 2025.
Hmm.
Here it is stated that সন্দৰ্ভত শুনানিৰ প্ৰয়োজন বোধে অহা ইংৰাজী 6/12/2025 তাৰিখে পুনৰ শুনানিৰ দিন ধাৰ্য কৰা হৈছে। সেয়ে ধাৰ্য তাৰিখৰ দিনত 11 বজাৰ পৰা 2 বজাৰ ভিতৰত নিজ নিজ সমৰ্থনৰ তথ্যপাতি সহ নিম্ন স্বাক্ষৰকাৰী আদালতত উপস্থিত থকাৰ বাবে আপোনালোকক জাননী যোগে জনোৱা হ'ল। Let them place the documents before them, let the hearing took place. Let the hearing take place, Lordship. If something goes against him without.
No, but the circle officer must be aware that there is a litigation pending regarding the said plot of land. Which is not finally decided in view of the fact that.
In a
appeal is
demarcation proceeding, in addition to, if there is a civil trial is pending before the civil court, demarcation proceeding can be initiated as because no handing over of position. No handing over of
No,
position.
but what will be the ultimate?
Ultimately, if the civil court says that this is the plot, you go in the execution proceeding, he has to demarcate it and give the position, Lordship. In a demarcation proceeding, we cannot, Lordship. We cannot hand over the position, Lordship.
No, but this demarcation will be subject to the outcome of the appeal.
Lordship. So let them place
What
all
is
these
the-
things
what-
before the
what is the
trial,
point
before the
if-
circle officer.
No, what is the point of the circle officer going ahead for demarcation? When the.
He will have
the
to see
The
whether.
issue of demarcation is sub judice before the appellate court.
That is true, Lordship, but whether this civil proceeding relates to that particular plot of land or that, he has to,
But that is
they
for- That is for
they
the.
have to
review.
show it before the circle officer.
That is.
Page 147 and page 150.
When the hearing takes place, Lordship,
Huh.
they can very well place all these things. If he is satisfied, he will stay it. If he is not satisfied, if he is goes against the law, he can very well approach this honorable court.
When is the next date?
Next date, not fixed.
But at this stage, most probably, Lordship, this writ petition is premature.
No, Your Lordship will find at page 147, we had intimated them, the circle officer that.
Yes, Lordship, he has intimated regarding the pendency of the civil suit.
And
But-
again in page one fifty.
No hearing takes place till date, Lordship.
No, that's right.
So
So,
let them place all these things on the date of a hearing. If it is against the law, then he can very well approve this honorable court. But at this stage,
Demarcation.
whether
takes
that,
place
where is,
when
the-
cause of
where is
action
the
arises.
notice? Where is the notice?
at page 155A, last notice, Lord.
It starts from page 146 was the first notice. And against that, we had intimated immediately about the pendency of the civil suit.
Where is it? Where is the order of the trial court?
The
Page
trial court
58.
judgment, your lordship, decree, your lordship.
So you will find at page 144 that I was about to draw my lord's attention. Page 144, lordship, kindly see. Page 144, my lord, in the middle portion, it is ordered and decreed that the suit is partly decreed on contest. The plaintiff are entitled to declaration of their right title and interest over the suit land. That is the Schedule B land. Lordship will find here, my lord, two schedule lands, Schedule A, Schedule B. Plaintiff here.
Who are the plaintiffs here?
Yes, the
Plaintiff is
preceding
respondent
page.
number 4.
The preceding page, lordship will kindly turn it. Lordship will find, my lord, one Ramesh Chandra Chaudhary. Now, he was the plaintiff. Now, he is, my lord, party respondent here. That is a private respondent. Now, perhaps, since, my lord, the civil court has already passed a decree for declaration of right title and interest over Schedule B land, and since there is another land, Schedule A land, so therefore, my lord, an application has been laid before the circle officer for demarcation. And the circle officer is not, my lord, restrained by any court of law. Since there is no stay order admittedly, as has been spelled out by my learned colleague. So if there is no
But
stay,
the schedule does not relate to the schedule of land in the notice.
No, this is the new, after the settlement, the names have been changed because it has been clearly mentioned by us in our page 147. Your
No, no,
lordship.
the question is whether the demarcation is with regard to the suit land.
Yes, it
or
is with
some
the
other
suit
land.
land. It is with regard to the suit land because your lordship will find that what my learned colleague has taken your lordship's attention to the final part. I'll take your lordship to the other portions because the judgment has to be read as a whole. And for that purpose, your lordship may kindly come to page 74, your lordship. '74, there were two things with regard to the challenge was made in the suit that my predecessor had dispossessed them. Now, and obtained Khatian illegally. First finding was that the Khatian was not obtained illegally. And secondly, in page 79, issue number 8, it has been clearly held that the plaintiff has not been able to prove that the defendant had dispossessed them from the suit land. So we are also in possession of the suit land. If your lordship sees page 79, issue number 8, the first part, it is clear that I have not dispossessed them from the suit land. And secondly, in issue number 9 also, that in the at the bottom, it a consequence thereof, the plaintiffs are not entitled to any declaration as to the existence of any non-existence of tenancy, etc. Now, taking all these aspects, this part of the finding was challenged by the predecessor of the respondent number 4, who has now been substituted in this case, which your lordship will find at page 91 in RFA 51. The lordship will find by the registry.
No, we are not on that.
Yes.
You see, the dispute now relates to Schedule B land.
Yes. No, he has not specified as to Schedule A or B. He wants the suit land to be demarcated and.
No, kindly come to the notice at 146.
Yes, your lord.
This is very clear that this is with regard to this particular plot of land.
Yes.
Specified.
Yes, your lord.
And this is not Schedule B land.
The Schedule B land is, at that point of time, was 10 lesser. 10 bighas.
Hmm.
Now it appears that he have told it, and we have raised this point before the. Your lordship will find the schedule in the plain.
Tag
is
number,
given.
pattern numbers are all different.
Yes, after the pata numbers have been changed.
Because my lord, this decree was passed in the year 2014. So thereafter, my lord, my lord, taking up the resettlement operation, perhaps the DAG numbers have been changed. So here is a case, my lord, the circle
Your
officer has
lordship will
taken
find
up a
that page
boundary.
147, we have mentioned clearly. I bet if your lordship comes to page 147. Because if your lordship sees the original, the schedule in annexure, page 43, schedule A and B of the plain is given. And then I will take your lordship to page 147. Here, the petitioner before your lordship had raised this before the circle officer, second para, that I beg to state my deceased father was the occupancy tenant of a plot of land measuring more or less 10 bighas such and such under DAG number 688 old, which has now been renumbered as 5211 of this and EB Patta number such and such, etc. Now, this is the present notice is referred to as this notice, your lordship. In the notice, your lordship will find this is the new DAG number and Patta number. And this is the subject matter. In the third para, we have categorically stated that this is the subject matter of the two RFs pending before this honorable court. And so, because there is an issue with regard to the area of land in possession of both of the parties, a demarcation exercise at this point should not be done. That is what we had highlighted before the circle officer. But in spite of this, because this was the first notice, we had immediately responded. In spite of that, a second notice was again issued, to which we in page 150 again responded to the same by filing our again objection to that. But in spite of such repeated intimation given to the circle officer, he is proceeding ahead with the demarcation.
So when is the next date?
He has stopped issuing any dates, but
Then
May I please one thing, Lord? In annexure 4, 147 page, here the prayer for objection is made by the petitioner. He has only mentioned about the case pending before this honorable court. He has not submitted any documents. That is why I'm stating repeatedly that when the hearing takes place, let him place all these documents before the circle officer, let him go through it.
we have
Whether it's
already
related to
submitted.
that
Oh, I have
land
not
or
annexed it out
in
here.
view of this objection,
Yes,
some order was required to be passed by
but
the
Lordship,
circle.
no hearing takes place still there, Lordship.
Huh?
No hearing takes place still there.
He
Lordship.
sits in the office.
Most
but he
probably
does
the
not
other
pass any
party is taking
effective order.
time repeatedly. Maybe. That is why these 3-4 notices. That is why I'm placing that. Let him place all these documents before the circle officer.
These documents were placed in earlier also.
Yes,
And your
only
lordship is
mentioned
well
about
aware
the
of the functioning
pendency of
before
the
the circle officers, your
Well, I
lordship.
heard Mr. A. Biswas, the council executive. Mr. H. Sarma, appearing for respondent number 2-3.
Respondent number 2 and 3.
Mr. R. Kusari for respondent number 1. This petition is filed by the petitioner who claim to be tenants and occupants of land measuring 10 bighas, 1 quota, 13 lechas under DAG number 688 within bracket old /5211 of EB Patta number 52 bracket old /EB Patta number 959 of village Potakhil within bracket ST Sohor /NC bracket close under Moza Beltola Circle Dispur District Kamrup Metro Assam. In respect of this land, a title suit was instituted by the predecessor in interest of respondent number 4. the suit was partly decreed in favor of the plaintiff. And pursuant thereto, both the plaintiff as well as the present writ petitioners are before the appellate court by filing their respective appeals. Stop. The appeals are still pending before the appellate courts. Para. The petitioner before this court is aggrieved by the notices issued by the circle officer calling upon the petitioner for demarcation of the plot of land measuring 9 bighas, 4 lechas, bearing DAG number 5211 of EB Patta number 959 of village of Patakil, Moza, Beltola. Stop. The petitioner has urged before this court that it is the same plot of land on which the trial court has partly decreed suit, and against the judgment of the trial court, appeals and cross appeals have been filed before the appellate court and are still pending. Stop. It is the submission of the council that since the question of the right title and interest over the said plot of land is pending disposal for the appellate forum, the revenue authorities ought not to have accepted any application for demarcation of the said plot of land, which is the suit land. So, Mr. Biswas, counsel for the petitioner, submits that as on date, no specific orders have been passed, but several notices for proceeding for demarcation has been issued on the respondents' stop. It is submitted that during the pendency of the appeal, when the very question of the title is presently sub judice before court of law, the question end of ligo, the necessity of demarcation of the suit land by the revenue authorities is or would be an exercise in futility, as mere demarcation does not give any right over the said land unless the same land is identified and handed over to the respective parties. Stop. It is submitted that since the matter is still sub judice before the appellate court, the circle officer ought not to have proceeded for demarcation. And accordingly, apprehending that the circle officer will proceed for demarcation, present writ petition has been filed. Mr. H. Sharma as well as Mr. R. Barbuzari, counsel for the respondents, strongly objected to the submissions of Mr. Biswas. It is submitted that this writ petition is premature. As on date, only notices are issued, no specific orders have been passed,
And no hearing.
and no hearing has taken place. Therefore, there is no need for issuance of any orders by this court in the present writ petition in the present form. Having heard counsel for parties, it is seen that the suit land is mentioned as per Schedule B of the judgment passed by the trial court. It is not in dispute that the said judgment of the trial court is pending in appeal and cross appeals filed by both parties before the appellate court. Stop. It is also seen that in response to the notices issued, petitioner has also filed objections before the circle officer, bringing out the fact that the demarcation process sought to be initiated is in respect of the suit length, and the same ought not to be done as the matter is pending before the appellate court. Stop. Having considered the submissions made by the counsel for the parties and upon perusal of the pleadings upon on record, at this stage, the court is of the view that notice should be issued, since the private respondent is also arrayed as a party. Therefore, let notice issue returnable 4 weeks. Since the respondents 1, 2, and 3 are represented, notices away, the extra copies be furnished within a period of 1 week. Steps on respondent 4 by registered post within 1 week. Till the next date fixed, the circle officer till the next date fixed, the proceedings before the circle officer in respect of
Boundary case.
demarcation case.
Boundary case 49 of 25.
Boundary case 49 of 2025. Pertaining to plot of land measuring 9 bighas, 4 letters bearing tag number 5211 of EB, patta number 959 of village Fatahil, Moza Beltola. Shall not be proceeded with. Further orders, if required, will be considered on the next returnable date. List accordingly.
Not the matter pertaining to non-payment of, my lord, the bill of a Gosala, my lord. The liability has already been admitted.
So again, non-payment would be bench 4. Is it bench 4?
Bench 4.
Non-payment. I don't know why they
My lord,
listed here.
even we have requested to the filing section, but they are saying that.
Hold on. They give a change over, na? Why are they listed here? They submitted at the bar that this matter pertains to civil bench 4. Therefore, registry to verify the same and listed before the appropriate bench accordingly.
Well.
For the time being, Mr. HRS will appear for the caveators, Miller. Though our name not shown in the course.
Because my lord, after my lord filing this petition, probably they have filed caveat.
They-
Even then
they-
I have, yesterday I have sharp copy.
Yes,
of
yes,
the
yes.
matter.
Copy receipt, Miller.
Yes,
Copy receipt.
I have sharp copy.
No, passes.
Hmm?
Copy passes.
Caveat
What
is not enclosed here.
Yes.
When did you file it? After filing?
Maybe.
And then,
A copy already received, Miller.
so what do you want now?
For the time being.
For the time being?
Yes, Miller. Mr. HRS will get there.
All right, we'll call it up before we rise at 1 o'clock, before rising.
Yes, yes. Yes.
Yes.
Before, sir.
32. Yes.
May I please, your lordship? My lord, the petitioners are the my lord members of the particular selection committees of their blocks, my lord, and they have selected certain beneficiaries, my lord, for the Arunodaya 3.0 schemes, my lord. But my lord, arbitrarily they have not been included, and all these persons has been left out, my lord. Though no reason had also been cited, my lord.
Which persons?
My lord, the list which we have annexed, my lord.
Yeah, who are you?
My lord, we are the members of the committee who did select these persons, my lord. And they fall within the category of the guideline, my lord, which the government has issued. And we in fact, my lord, made several representations, my lord, but nothing is, my lord, has been taken into
Yes,
account.
Panchayat, anything? Huh?
Deputy Commissioner.
The DC.
Let the notice go at this stage, but you have to obtain instruction.
All right, Leonard Council for Party, we should notice return over 4 weeks. Mr. Borpujari, R. Borpujari appears for respondent 1.
2 and
Mr.
3.
H. Sharma for respondent 2 and 3. Mr. Ghosh for 4. Since the respondents are represented, notices are waived, extra copies will be furnished within a period of 1 week from today. List after returnable date.
Right, my lord. 33.
Yes.
In this
Let
case,
leave.
Lordship, let the matter be fixed on Friday, Lordship.
Hmm.
Only a demarcation proceeding is going on today. The date is fixed today. Let the, I had a talk with the circle officer. There is some
Well,
most probably
let it come on Monday.
Monday also, Lord.
Second.
My lord,
At least I can assure that in the process of demarcation, no handing over of position will be done. Only demarcation, Lordship, no handing over. That is the settled law, Lordship.
my lord, only my respectful submission before lordship is this, my lord. Today is the date fixed for the demarcation, but prior to that, earlier a date was also fixed for the same purpose, to which we have filed our representation that this plot of land is the common passage to our Jain temple that is lasting for the last more than 30 years. And this is the common passage to which the proposal has been given for the demarcation. If this process, if this passage is blocked in the meantime, then entire Jain community would suffer. Because we are having a 10 temple, Jain
That is why
temple
I'm-
as well as the prayer
Yes.
hall.
That is
He
why.
has- He has given, he has made a submission.
My lord, status quo be maintained till the disposal of this petition, my lord, because
Let-
we
let
are the
it come
In that case,
accused
Lordship, the
person.
demarcation proceeding
Second.
cannot proceed, Lordship.
And we are apprehending because on the last so many occasions,
All-
some apprehension is there to demolish our structures.
All right, all right.
No,
Mr.
That
Your-
will not be done,
apprehending,
Lordship.
my
No,
lord.
Lordship.
Your
That will
Mr.
not be done.
Occasion, my lord.
AK Jain Council for the petition.
Till then, status quo. the
Mr.
matter
H.
will be maintained,
Sharma,
my lord.
learned Government Advocate appears for
2 and 3.
respondents 2 and 3.
I will get that instruction on Monday.
Mr. R. Borpuzari for respondent number 1. Oh, why is respondent 4?
Man, the respondent for is the private party. It is the unit of a political party to which the land has already been allocated without due process of law.
The-
They are occupying the portion of the land.
The petitioner is a trust and represented by its authorized representative. The trust runs a temple, Jain temple,
Jain temple, my lord.
which is located on a plot of land.
My lord, photographs have also been annexed at first 35.
covered
Yes,
by
25,
number
26,
26,
27 was the
KP
photograph.
number. What is the plot of land on which it is located?
Common passage.
No, your temple.
Temple is just behind the common passage. And this is the only way to go to the temple.
No, your temple is located on what is the
Located in our own plot of land. At
what is the
Guwahati.
measure of the land?
My lord, I have annexed at page 20. This is the Jamabandi of the land showing our name. Read petitioner name has been shown Digambar Jain Panchayat Mahavir Fund Trust. Page 20 of the petition. Page 21 and 22. This is our plot of land on which the temple has been constructed long back. And thereafter, my lord, page 22 may kind of be seen. That is the settlement in favor of the private respondent number 4. In the meantime, they have settled the land without due process of law.
On a plot of land, this land
Majority
And dark number 2033 is our land.
where have you stated that?
in paragraph 3, Lordship, page 6.
No, 2033 is not here.
My lord, 2033 is the dark number on which the land temple has been situated. And
Covered by dark number 20.
next page is 22, dark number 1985. That is a separate dark, but our common passage is on this particular dark 1985.
The access to the temple is through a common passage, which falls under dark number 1985. Stop. This plot of land, it is used as a common passage for ingress and
Ingress and
egress to the temple by the members of the public as well as members of the trust and their community, has been handed over to respondent number 4 without following the due process of law. The counsel for the petitioner submits that if this land, plot of land, is handed over to respondent 4, the common passage for ingress and egress to the temple would be blocked, and the members of the community will suffer immensely as the temple cannot be used by its members. Stop. It is the submission that this particular plot of land has been handed over without following any process, due process of law. Where Mr. H. Sharma on the other end, government advocate, submits that the demarcation process is fixed today. Today. He therefore submits that the matter be listed on 2nd of February, on which date he will have proper instructions with regard to the
I'll
result.
place the whole report, Lords, before Lords.
the
My lord,
demarcation process,
my
the law-
representation
the
file
court-
already may be disposed of in the meantime.
Stop. Let this matter therefore be listed again on 2nd. It is made clear that till the next date fixed, there shall be no handing over of possession, although demarcation process may be carried on.
My lord, in the matter,
Although.
I'm sorry, my lord,
Although notices are not issued, extra copies be furnished to the respondent counsel during the course of the day. Yes.
my lord, one submission, my lord. At page 30, I have filed a representation. At page number 30, that representation was filed on 24/10/25. That this entire process is quite illegal. But that representation is not yet disposed of. In spite of that, again, the demarcation notice was issued.
We'll consider it on 2nd.
My lord. Till then, status quo,
Yes.
parties may be directed to maintain status quo as regard
Not
to the
status
city
quo,
president,
we have directed them not to hand over the possession.
not to hand over or status quo be maintained as on today, my lord.
No, no, no.
Because we are using the said passage for last 30 years, my lord.
Status quo may go against you.
My lord.
Status quo may go against you after the demarcation process. We are not staying the demarcation process.
My lord.
So the demarcation process be there, but the handing over shall not be done. Till the next date.
Some specify real maybe because we are apprehending that in the meantime, they may demolish, they may cause the damage to our structures. Because we have.
It is
So,
also
in
made clear
demarcation
that
proceeding, all these things.
My lord,
Not be done.
revenue or the state authorities will not proceed for demolition or
Any kind of
interruption, demolition of the temple or any.
No temple, common passage, my lord, scheduled premises, temple premises, common passage, my lord. Temple is there in my own.
In that
own
case, Lordship,
plot
they
of
hope.
land.
So
Whole
what is to
process
be
will
demolished
stall.
in the common passage?
Common passage, my lord.
What will be demolished?
Demolition or destruction or
Of what?
common passage, structure is
How-
there, my lord, gate is there, iron gate is there,
Ah,
structure is there, my lord.
So that is what we are saying.
Yes, my lord, I have.
Demolition
I
of
have
the
mentioned
boundary
it.
wall or the gate
I'm
of the temple.
Lordship.
Yes. Yes.
Only demarcation, Lordship, only demarcation. And I will place the report on that.
Yes, yes.
My lord.
Timing item 27. What is possible?
May it please, your lordship.
Yes.
Lord, the petitioners are aggrieved by the eviction notices at page 61, my lord.
Yes.
This is to inform all concerned resident of Jarobari Moza Apuri Jorni, Kisamot, Dag number so and so. Westland government grazing reserve area. It's actually not grazing reserve, it's a government khas land, na?
Yes.
Has unauthorizedly encroached upon the government land as it is in illegal possession of the same by constructing hard structures, cultivating crops, etc.
Yes.
Therefore, through this office is directed that within 10 days from the date of receipt of this notice, he must voluntarily vacate and clear the encroached government land. If he fails to vacate the land within the stipulated time, then revenue administration will take action to evict him forcibly according to law. Further, he is directed to submit all relevant land documents relating to the said land, if any, to the undersigned within 7 days. Milord, there is no dispute that the land in question is a government land. We admit, Milord. Milord, our settlement proposals are pending, Milord, which your lordships will get at page number 138 onwards. Under the land policy of the state also, Milord, we are entitled to consideration as a landless people. Your application for settlement of khas land and selling surplus land has been submitted successfully on 13/3/23 and your acknowledgement is so. So similarly, we have given the acknowledgement in respect of all the other petitioners. Now, my humble submission is, Milord, in such a situation, will it be, Milord, fair to resort to this exercise of, Milord, the summary power? Because in the judgment, it could be. No, the judgment is like that. It could not. It could not have been this. No, heavy judgment. Next question. Milord, we have annexed that judgment, Milord, which your lordships will get at page number 148. Relying upon Salekuddin's case, Milord, if your lordships would kindly come to page number 146, Milord. Now, the Salekuddin's observations is noted, Milord. If your lordships will kindly come to Roman 4. Bona fide claim in case of government khas land or westland may involve a bona fide claim or right to claim settlement over the land on the basis of the settlement rules and extend land policy of the government of Assam. So, my Lord, Lordship knows in view of the judgment of our High Court that Decca's case and this case, my Lord, if there is a bona fide claim of right, then, my Lord, the summary powers under Rule 18 cannot be invoked. And this decision, my Lord, Salekuddin has also recognized, apart from anything else, the right of hearing also. Division bench judgment, my Lord. Now, eventually, if your lordships will kindly come to page 147, para 11. In the aforesaid settled proposition of law and factors recorded herein above, this court is of the view that the petitioner cannot be evicted in the manner as is sought to be evicted, that too without giving her reasonable opportunity of hearing as held in Salekuddin's case. That being the position in the considered opinion of this court, the impute notices issued to the petitioner is not even sustainable under scheme of Rule 18(2) of the settlement rules. Accordingly, the impute notices that it is set aside. However, it is provided that respondent number 2, Deputy Commissioner Dorong, shall still be at liberty to initiate proceeding of eviction affairs in accordance with law and in terms of law laid down by the division bench in Salekuddin's case. So, my Lord, since the case is identically placed, my Lord, I'll pray for a similar direction, my Lord.
Now, first thing is, if it is a grazing or a wasteland.
It's a government khas land.
No, if it is a grazing land.
Yes.
Then Jakpal.
Satpal. No, it's not a grazing reserve.
If it is a government land, then you have filed your applications.
I do not say that I have an absolute right of what I'm arguing. What I say is at least I have a right of consideration. Since our applications are pending, they should take a call on that.
Right. So who has given this?
That I have produced this, my lord.
Right.
As per my instruction, that is on these 2 days hearing were called for, my lord. Some of the petitioners have submitted their documents and others are not, my lord.
Then what
But
is?
whatever the documents they have submitted, it is basically made of holy ceremony, that receipt, my lord.
Oh.
Those are receipts. So they have yet to pass orders on hearing, my lord. As this matter is pending here, so they are not inclined to pass any order. Lordship may give direction to the authorities after submission of all the documents by all the writ petitioners, my lord, in a prescribed time. They will take the call on those documents, my lord.
No,
and
but
take
they
the
will take
hearing.
a call and the petitioner will again come to the court.
Yes.
So give us some concrete measures on which you want to
Let them
No,
do
proceed.
following
Otherwise,
this.
it carries no meaning that you'll, you see, they are occupants,
My lord.
which means that they have no land documents
My
other than the revenue receipts or whatever they have given. Now, if you give them an opportunity of hearing and they produce the revenue receipts,
my lord.
how does it establish their
No,
right
but
to
it's a
the land?
revenue
It doesn't.
receipt is Bedekhali Jarimana.
Meanwhile, if they have already filed their applications for settlement, some order is also called upon. Having these
That
applications being
instruction is
received,
not been provided to me.
and government will also have to take a call.
My-
They are basically human beings,
Absolutely
right?
correct.
So if you uproot them from one area, you must give them some area where either you identify that no, they originally belong to X or Y areas. They have they have come over and settled in this government or forest land. Then it's a different issue. You send them back, but you uproot them, and then where will they go?
No, my lord,
Or what will be the process thereafter?
now, my lord, there are 70 writ petitioners in the writ petition. Out of 70 writ petitioners, so far as my lord settlement proposals are made to the authorities, in the writ petition, we find that, my lord, there are only 5 settlement, my lord, applications seeking settlement. So therefore, my lord, the 65 writ petitioners, whether they have made any settlement applications before the authority, that is not known from the writ petition, number one. Number two, what Salason dictums is that, my lord, you can evict them, but you cannot summarily evict them without giving them a
giving the
notice.
hearing.
And notice it will, in the nature of a so-called hearing, which has been rightly done by the authorities. So Lordship, at this stage, maybe pleased to protect them in the interim, so far as, my lord, my lord, relegating the authorities to take a decision on the matter. Once the authorities take a decision, my lord, on the applications filed by the respective petitioners, then thereafter it will be a separate course of action. Because at one point or another, it is only the revenue authority who will have
No,
to come
you
to a
get your
finding.
instructions then.
No, my lord, these instructions are already placed before my lord.
No. What steps will be taken in respect of the settlement process?
No, settlement process, therefore, everything will be done in the hearing of, my lord, individual hearing in respect of each of the
Individual
petitioners.
hearing is for eviction.
Government.
Is eviction. But the settlement will not be done by the same authority in this hearing. There has to be a process that they have applied for this land, these certain lands are available, or maybe the land in which they are presently occupying, part of the land may be settled with them. So there's a process.
So there is a process, but, my lord, at the same time, the land policy, my lord, mandates that mere filing of any settlement application will not entail them, my lord,
Quite
give
right.
them any right. Now,
But if
my lord,
you,
my
if you
respect,
see, filing an application is nothing, but making a prayer before the government that you are the owner of the land, give us some land to settle.
absolutely,
Right.
absolutely.
So some order is called for.
No,
Either you say that no, it is not absolutely not maintainable, we are dismissing at the threshold. Or some order that yes, we are taking a call on this, and people belonging to these areas or these documents, we are proceeding to settle them.
In that view of the matter, Lordship may be pleased to fix this matter next week, my lord. We will come up with instructions so far as, my lord, 5
Pending
settlement applications are concerned. Because out of 70 petitioners, only 5 settlement applications
No,
are.
para 7 we have made this statement.
The statement is there, my lord. I am not going by the statement.
Look at it,
I'm not.
we'll bring on record all below. As a model, we have given those.
Heard.
On the next step, my lord, we will bring instructions so
P.N.
far as, my lord,
Chaudhary.
these 5 settlement applications are concerned.
Assisted by Mr.
Jed Khalid.
Z.
Khalid.
Ali. Counsel for the petitioners. The petitioners, how many are there? 68.
68, huh?
70.
70, Mr. Sorry.
70 in
Sorry,
number
70.
are occupants or residents of The address is mentioned in the district of Nogam. The petitioners are aggrieved by the notices for eviction issued by the circle officer on 12/1/2026. By the said notice, they were called upon to submit necessary documents on 17/1/26 and 19/1/26. And the hearing will be held in the office of the said circle officer. Stop. In response to the said notice, some of the petitioners submitted their documents. However, no final orders have been passed. And the petitioners apprehend that since no orders are passed, the authorities may proceed to take steps to evict the petitioners from the said land concerned. Stop. Mr. K.L. Chaudhary, Senior Counsel, has referred to the judgment rendered in by coordinate bench by order or judgment order dated 29/8/2024, passed in WPC 1349 of 2016. It is submitted that the authorities are duty bound to follow the law laid down in a judgment rendered by division bench of this court in MD Salakuddin versus State of Assam and others reported in so and so. Stockmead submits, therefore, that without the proper hearing, the authorities cannot evict the petitioners as sought to be done, and therefore appropriate orders be issued by the court restraining the respondents to stay the process of eviction. Where Mr. Borpuzari and Learned Common Advocate submits that the process of hearing is underway. As per the instructions received, some of the petitioners had submitted the necessary documents. However, not all the petitioners have been able to furnish any valid land documents, allotment letters, Jamabandi, etc. Stop. The matter is currently under examination by the circle officer Roha, and upon conclusion of the hearing, the authorities will proceed to take necessary steps for eviction if required, as per the procedure prescribed under law. Mr. Borpuzari submits that he be permitted some time to complete his instructions in the matter and place all necessary documents, including any orders that may have been passed by the circle officer in respect of the claims made by the petitioners. You want us to issue notice?
Please issue a short notice, madam.
2 weeks.
Under such circumstances, since this matter will require some hearing, that notice issue returnable on 20 February. Since the respondents are represented by their respective counsel, notices are waived, extra copies be furnished within a period of 1 week from today. Since the respondents have already submitted that the process of hearing by the circle officer pursuant to the notice issued is underway, and the matter is and no specific orders have been passed, we permit the respondents to proceed with the hearing. However, no final orders will be passed without leave of the court till the next date fixed.
So the
List again on 20. Extra copies be furnished within 3 working days.
I'm so obliged.
Yeah, please, Your Lordship. Here in this case, Lordship, the petitioner was elected as an AP member, Lordship. And he has been, Lordship, declared as disqualified on the ground that he violated the legal age of marriage. That
He
is
violated the
legal age of marriage, lordship. That is under section 1112F. And rules, lordship, 62(4) BC. My lord, my submission would be that the marriage, lordship, that took place in the year 2012. And that amendment has come only on, lordship, 19/10/2023. So this provision, lordship, there is no retrospective effect. So this provision cannot be applied in respect of
where is the impugned order?
impugned order, lordship, page 22.
But Mr.
M. Khan.
M. Khan, learned counsel for petitioner, and Mr. Endas of the state.
State, my lord. Two.
Respondent two.
Two, my lord.
Petitioner is aggrieved by the impugned order dated 19/12/2025, whereby, as per provisions of section 111 within bracket 2 of the Assam Panchayat Act 1994, read with the rule 62(4)(b) and C of the Assam Panchayat within bracket Constitution Rules 1995. The petitioner was elected as the Anchalik Panchayat member from 74-Patamari Gaon Panchayat, was disqualified and removed from the Anchalik Panchayat member with immediate effect. Stop. As per the said order, petitioner has violated the legal age of marriage under the Prohibition of Child Marriage Act 2006, and therefore has rendered himself ineligible to be elected as a member of the Anchalik Panchayat. Para being aggrieved, present with petition has been filed. The counsel for the petitioner submits that the amendment to the Prohibition of Child Marriage Act with regard to the legal age of marriage was brought on
19/10/2023.
1910
19/10/2023.
23
And another one is, lordship, 24/12/2024. That
and
is the
24
24/12/2024. That is the Assam Panchayat Constitutional Rules 1955. 1990.
2024. As far as the Assam Panchayat Constitutional Act is concerned, the learned counsel therefore submits that the marriage took place in 2013.
2012.
Huh?
15/3/2012.
15/3/2012, and therefore the subsequent amendment of enhancing the legal age of marriage in terms of the so and so act and the corresponding amendment brought into the Panchayat Act, Panchayat rules, cannot were not made retrospective, and therefore cannot be applied retrospectively to the petitioner who was married well prior to the amendments brought. Stop. It is submitted that when any amendment is brought to any statute or rules, unless it is specified, the same shall not operate retrospectively by default. Stop. Under such circumstances, the impugned order dated so and so disqualifying the petitioner who was married well prior to the amendments brought in is bad in law, and the same should be interfered with, set aside, and quashed. The considering the issues involved, let notice issue returnable 4 weeks, since Mr. Das represents respondent 2. And Mr. A.K. Ghosh appears for respondent number 1345. Notices are waived in respect of respondents 1 to 5. However, extra copies will be furnished within a period of 1 week from today. Steps on respondent 6 by registered post within 1 week from today. Matter be listed again on 6th of March Since the court is presently in session of the matter, the post of, what is that post?
Anchalik Panchayat member,
Anchalik
Dharmashala
Panchayat member of so and so Gaon Panchayat, which was held by the writ petitioner, shall not be filled up without the leave of the court.
Yes, madam. Not be filled up.
Obliged.
May I please, Your Lord? My lord, these are the matters which were disposed of, my lord, yesterday with a direction to the authorities, my lord, that our replies should be taken into account. I have given a copy of the order, my lord. The morning in.
These
item-
matters were disposed of.
No. These were
Similar matters.
Similar matters.
Ah.
My lord.
This extra copies were only served on yesterday, my lord.
Which is disposed of.
No, not regard to the other case, my lord.
This
This
matter.
51, 52, 53, my lord. So, my lord, necessary instruction could not be taken, my lord.
Oh, so you want it on Friday, tomorrow?
Tomorrow, my lord, because
My lord, not.
51 and 52.
51 and 52, my lord.
You get it tomorrow?
Wednesday, my lord.
My lord, in the
Wednesday.
meantime, my lord.
Then don't evict them. Status quo. Or if you want it by Friday or so, we can.
Difficulty is that, my lord, after
If-
obtaining an interim protection, my lord, they ought to give the copies immediately, my lord.
No, there is
No,
no.
we are not
order.
inclined to issue interim, but if you can get the instructions within a day or two, we'll fix it accordingly.
So, my lord, my respectful submission, they ought to have given the copy immediately thereafter.
Immediately, my lord,
They-
my lord,
it-
hard copies were given on the
Our
day,
predicament also.
by the day itself, my lord. We have
Why
the
do you?
The copy.
No, my lord, yesterday, the note.
You give physical copies.
physical copies on the same day we have given, then soft
Why
copies.
don't you give them soft copies?
Soft copies were also given, my lord.
My lord.
My lord, I have. that
Idea.
record, my lord.
Localization.
Soft copies
Localization.
were also given, my lord.
Difficulty, my lord.
My lord.
So we kindly consider our predicament also, my lord. We have to communicate to the officers.
No, but copies are required to be served at the time of filing also.
Yes.
Also, soft copy, extra copy. my
Soft
lord, that
copies
is-
I had given.
Soft copy also will do, my lord.
Yes. Nowadays, we can immediately transmit, my lord.
207 pages.
I have, my lord, furnished it to Mr. My senior friend N. Goswami, my lord, soft copies, my lord.
Yesterday.
So you furnish soft copies only after issuance of notice.
No, my lord, on the day my lordship directed, my lord, by night I have given.
When you
it.
file a matter
My lord,
for standing counsel, government advocates, you serve extra copies.
extra copies, my lord.
Physical mode,
Physical mode, my lord.
no soft copies.
No, my lord. Soft copy is not required to be given, my lord. If they are requested, we generally.
We will see whether we can
My lord.
direct issue some orders that
My lord.
at the time of filing, give a physical copy, give a
Yes,
soft copy, that will
Copies
take care
also,
of
that
it.
will be better, my lord. That will be better.
Not even at the time of filing, after.
No, at the time of.
Time of
Notice has been issued. by-
They are already giving you a physical copy
No, physical copy.
at the time of filing.
Yes.
My lord, Lordship would kindly appreciate, my lord, once the petitioner side, gets an interim protection, it is incumbent upon them.
No, we are not on that.
Soft copy.
We are not on that.
The most
What we
are-
want to say,
My lord.
at the time of filing, a copy is mandatorily served on government advocates and
Yes.
planning council
Yes.
in the physical mode.
Physical.
So why not add another soft copy
Yes.
at the time of filing?
My lord.
That will take care of all the.
Nowadays, my lord, scan copy is required to be, my lord, submitted before the registry, my lord. So
Ah.
that copy we can also serve to the
Correct.
council also.
Correct.
Only, my lord, the cases are similar with regard to yesterday case.
All right, then,
Only, my lord, my instructions are
what you
required.
want it next week?
Next week, my lord.
Right, matter be listed again on 4th of February.
My lord.
In the meantime, status quo
Yes.
as on date be maintained by the parties. Extra copies must be served on the respective councils during the course of the day,
We have
in
al-
which
we have already
interim
served.
order stands
We have
vacated
already
without
did.
further reference to the court.
My lord. Soft copies right now I am again furnishing.
yes.
My lord. Obliged, my lord.
53.
Yes.
Please, Lordship petitioners or Lordship settlement, they have just settlement in 4 Dokwania village, Lordship. They were given settlement by these are river eroded people, Lordship. Since 1950, they were shifting their.
We had passed some orders in this Dokonia village
Not aware.
last week. Anyway, so
So Lordship, now Lordship,
Where-
they
where
were
is the-
settled by the government Lordship. In 1997, they were given land documents. I have enclosed them Lordship.
okay.
Lordship, now 4-number Dokonia village, some of the revenue officials say that you, out of 113 families, few of the families do not belong to 4-number Dokonia village. You, as per the new survey carried out with the help of satellite Lordship, you are to be situated in 1-number Dokonia village.
Okay.
So 1 number is PGR land. And ours are de-reserved land, and we were given settlement by the government, by the revenue officials with proper demarcation. Now we are disturbed because of the fact that Lordship, a notice has been issued Lordship, common notice Lordship. It is at page 82 Lordship. It says people who do not have Lordship land documents in PGR land under 1-number Dokonia village, they will be evicted. So we initially belong to 4-number Dokonia. Now few of the revenue officials without any proper documents served on us say that we may fall under 1-number Dokonia. These are the predicament, Lordship. But we, as per their own settlement orders and settlement given to us by proper process by the revenue officials, Lordship, in the presence of Lordship Circle Officer in Lordship, while giving us the settlement, we were given the land, we were handed over the land. Now they say we are not in 4-number Dokonia. We even have a market, a Panchayat market is also running in the area, Lordship. We fear that if we are shifted to 1-number Dokonia, which is a PGR land, we may be evicted. Because we have land records.
Page 82 is says, my lord, this is notified that as per the Assam Land Revenue Regulation, the persons who are unauthorizedly occupying and encroaching upon the lands covered by PGR number 19, 22, 23 and 47 of number 1 Dokonia village. My lord, now they will have to prove whether they are the part of this.
Not me to prove, Lordship,
My
but
lord.
the revenue officers.
So
have
their
to prove.
claim is that they are not a part of, or they
Okay.
believe they were not a part of.
If they are not the part, they'll not be evicted, my lord.
So how can we
But-
prove?
but
Lordship?
you have
Till
the
that
land
notice has been not
Lordship,
served.
we have the land documents, Lordship. Some of us even after settlement were given, Lordship, after some land were given 2 bighas of
Huh?
to each family.
It's a
Lordship.
pre-measured, my lord. Sarakuddin will follow,
Lordship,
my lord.
Lordship, my friend may say pre-measure, Lordship. After being evicted, Lordship, where will be moved, Lordship? We have even some Yadipata land in the areas of Lordship.
All right, the
Some-
circle officer let him verify it.
Lordship, exactly, Lordship.
Let him verify with all
Lordship,
the
he will have to verify.
respective documents.
How a blanket order can be passed, Lordship, like this? And people from the revenue department say that you
My
are
lord,
under
the
1
notice,
number Dokonia.
if your lordship come, the notice is of 26/12/2025.
Hmm.
Now it's more than a month, my lord. Only 15 days time has been given. No steps has been taken. As per their, my lord.
Have you filed it before the authorities?
Yes, my lord. They have also filed an application also,
Lordship,
my
we
lord.
have filed an application, Lordship.
30/12/2025 representation. Let that be disposed of, my lord. With a speaking order. If this has not been Annex 7, my lord, page 84.
Lordship, let him bring some instruction, Lordship, that will also serve the purpose, Lordship.
Instead of keeping it pending, my lord, with a time frame, let this representation may be disposed of, my lord. Because it's more than 15 days, no coursive steps has been taken. It shows, my lord, that does not fall under these numbers.
I think it is better if the authorities decide on this matter, because you can present your side of the case.
Lordship, we will give a fresh representation because why, Lordship, this representation I have seen, Lordship, not very well drafted, Lordship.
All right, you give a proper representation. Let them give a proper representation. See, if the authorities are of the view that they have been are in this PGR land, obviously they'll have to vacate, but according to them, they have been given land documents by the revenue authorities at that
And
time.
Lordship, Miyadipata also.
My lord, that's why, my lord, that's why, my lord, if your lordship come to page 82, 15 days time has been given. No action has been taken.
That's
It
right. So
shows, my
Some
lord.
reason, Lordship.
Let
Again,
them,
it
let
is-
them,
It says fresh.
in response to this, we will extend the time.
Yes, yes,
Let them go and file their
yes.
representations, applications, whatever is there,
Yes,
along with all documents, and
Yes.
circle officer will thereafter hear the matter.
yes.
One representation has already been filed by them.
They want to file another detailed representation.
Then
Mr. M.
we
Bhagavati.
need to fix a time frame.
Yes,
my
of course.
Time frame.
Learned counsel for the petitioners. And Mr. N. Deka, learned counsel appearing for the respondent number.
And thus, my lord.
Yes, and.
2, 3, 4, 5, 6, 8. 2,
Two,
4, 5, 6, 8.
2, 4, 5, 6, and 8. Mr.
I'll
Or Pujari
for
for
free, madam.
respondents 1 and 3. The petitioners, who are 21 in numbers, claim to be residents of
Number 4, Dokonia village, madam.
number 4 Dokonia village in the under the Poschim Bongshar Moza, Hajo Revenue Circle, District Kamrup. Petitioners claim to be flood affected or eroded families who were uprooted and were given these land by the government at the relevant point of time. And since then, in the year 1997, and since then, these families have been residing in these areas and they have valid land documents. Stop. The petitioners are aggrieved by the notification, by notice dated, where is that?
Lordship.
1912.
Page number?
Page 82.
82.
82.
By the notice dated
2612.
26/12. Whereby the petitioners who were occupying or encroaching upon lands covered by PGR number 19, 20, 22, 23, and 47 of number 1 Dokonia village under Hajo Revenue Circle, Kamrup district, have been instructed to vacate and hand over possession of the land within 15 days. Stop. The learned counsel for the petitioner submits that they have been settled with their land since the year 1997 and they're in possession of the valid land documents, and nowhere is it mentioned that they are residents of number 1 Dokonia village. Stop. Therefore, the impugned notice which was served on them was on the basis of information which was on the basis of incorrect information, and the petitioners were not given an opportunity to opportunity of hearing before the authorities had contemplated to take possession of the said land. The learned counsel for the petitioner submits that a representation has been filed before the additional DC on 30/12/2025, which has remained pending and no orders have been passed. Stop. Under such circumstances, the writ petitioners are before this court, and it is submitted that without verification of the valid documents which the petitioners possess, they ought not to be evicted from the said land, as they are not residents of the PGR or VGR land under number 1 Dokonia village, but residents of the lands allotted under number 4 Dokonia village. So the respondent councils submit that they were given 15 days time in the said notice. However, they did not respond to the said notice by filing necessary representation before the circle officer, by filing their necessary documents, not representations. Correct. Having heard counsel for the parties, this court is of the view that the notice dated 26/12/2025, calling upon the respondents to vacate the land and hand over possession, did not provide any opportunity to the petitioners for a hearing and examination of their documents prior to taking any steps before the authorities. The representation filed before the additional deputy commissioner has also not been disposed of at this stage. Under such circumstances, this court is of the view that the interest of justice will be met, ends of justice will be met if the writ petition is disposed of, directing the respondent authorities, permitting the petitioners to file detailed representations before which authority?
My lord,
Circle officer. Circle officer.
So, my lord, let them file representation before the
Individually,
district
my lord.
commissioner.
Individually.
Let my lord, the petitioners file their individual representation. So this is the
The
Republic of
detailed
Salapati.
representations supported by necessary documents
Yes.
individually by the petitioners before the deputy commissioner,
Kamrup.
Kamrup. Stop the deputy commissioner or any authorized officer entrusted by the deputy commissioner will thereafter conduct a detailed hearing on a case-to-case basis
Yes.
by examining all the relevant documents and thereafter pass necessary orders.
Speaking,
If
individual speaking orders. my lord.
individual speaking orders, copies of which are to be served on the
Yes.
writ petitioner's stop.
Yes.
If upon such verification, the petitioners are found to be occupants of VGR or PGR land, then the procedure prescribed on the law will be undertaken by the state authorities.
Well,
The
only the,
entire, the petitioners will file their applications within 15 days from today,
Let-
along with all necessary documents.
let
Fresh
it be-
application.
Yeah, my lord, let it be within, my lord, 7th of February. Lordship fixes a date, my lord, that will, my lord, you can handle, my lord, both the authorities as well as the petitioner. Within 7th of February and let my lord.
Can you file it by 7th of February?
No, they will
Lordship,
have to, my lord.
Why is he forcing lordship?
not
They are
forcing.
shifting me from my.
So are you
settlement.
filing a representation or not?
Lordship, we will file.
Ah,
Definitely,
so-
that is what I am asking for, Lordship.
Ah.
On 12th, before 12th, Lordship.
Or by 13th,
Lordship,
by 13th
Lordship.
February.
13th of February and.
February, they'll have to file individual applications with all supporting documents before the authorities, DC concerned. And thereafter, the DC will proceed to hear the matter and pass individual orders within 30 days
30 days thereafter,
thereafter.
my lord.
Any such order that is passed, needless to say, the same shall be served
Yes.
on
yes,
the writ petitioners.
Yes.
Writ petition accordingly disposed of in terms of the above.
Lordship, in the meantime.
Copy of the order be marked to the office of the senior government advocate, Assam, for onward communication. Meanwhile, till such final orders are passed, no steps will be taken pursuant by the respondent pursuant to the impugned notice dated so and so.
Yes.
My problem.
And so, like,
Timing item 31.
Caveat, my lord.
Caveat is not here. Anyway, you have appeared there, served a
My lord,
copy.
I have some problem.
Yes.
This is regarding, my lord, election of my president and vice president of the, my lord, Gaon Panchayat. So in first meeting, my lord, in Gaon Panchayat, my lord, we are petitioner number 1 and 2, we are elected as the president and vice president. And only 4 members was present. The 4 members is a quorum, that is a fatal law. Now it is by division-based judgment. So then, my lord, they file against our selection, my lord, they file a representation before the deputy commissioner. After few days, they came before this honorable court. And this honorable court, my lord, then send back the, my lord, that the direction to my lord dispose of the matter, that this deputy commissioner will pass the speaking order. So accordingly, that speaking, I am against the speaking order, but that speaking order, my lord, they have stated that, my lord, the quorum is 7. That is why, my lord, that meeting which was, I was elected. That is no legal entity. So that is why pass, and now, my lord, first meeting has been called for. So against that order, I am came before your lordship. Now, your lordship kindly see, my lord, page 25, my lord.
Page
Yes.
25. So that is, my lord, the first meeting, Deputy Commissioner, my lord. The administrator would also, my lord, that is the president, and another one is page 27 is the vice president. So, my lord, thereafter, my lord, they file thereafter executive meeting also held, my lord. In the executive one, first executive meeting, my lord, in fact, some of the other members are also present, my lord. Now, my lord, when it is sent back by the, my lord, this honorable court, they had a meeting that
Who came before the court?
this present respondent. Have to
Then?
So now, my lord, your lordship kindly see the prima facie the speaking order is illegal because they stated is a quorum is 7, but this honorable court already held that quorum is 4, my lord. The 1/3 is 4, my lord. That is, yes, language is 1/3, 1/3 is, my lord, out of 10 it is 4 is, my lord, quorum. So that prima facie, my lord, it is that the impugned order is bad, my lord. Speaking order which I have challenged, my lord. Because, my lord, their contention it should be 7.
How many members are there?
10, my lord.
10.
10, my lord. 1/3 is, my lord.
Where is that finding? 7 members?
7 member, my lord. Your lordship kindly. Finding, my lord, raised by the speaking order.
Yes.
Yes, my lord.
Page 45.
Page 46, your lordship kindly see. Section 11 of Assam Panchayat, last part of the page 46, my lord. The Assam Panchayat empowered the authorities to dispute the election of the elected president, the vice president, the Gram Panchayat violating the fundamental democratic structure of the social. Till the quorum is the minimum number of members necessary to conduct the business, including his to 50%. That is four under the given technical technology lead to the absolute when the majority you will see majority. My lord, finding of a 7-member, sorry, my lord, page 46 first part, my lord. Page 46 first part, my lord. Rule 46(3), Assam Panchayat Constitution Rule 1995 mandate the quorum of the Bihar's meeting shall be minimum 7 out of 10 out of 10 meeting is adjourned if 1/3 or more than total number of members are not present in the meeting. The proviso of allowing the no quorum for an adjourned meeting in exchange with this general, which is expressly mentioned in Rule 46 of the Assam Panchayat Rule 1995. So now, my lord, your lordship.
No, what is the provision prescription in the statute?
46.
3.
3, my lord.
46(3).
My lord.
That is the rule.
Rule, my lord.
Is there any specification under the act?
Yes.
Under the act?
Under the act.
Act, my lord. That is, my lord. Under the act, my lord, that is not that procedure. It is, my lord, stated, my lord. Only that Gram Panchayat, my lord, election is, my lord. So far is, my lord, the president and vice president is concerned.
Section 18 of the act.
18 of the act, my lord, that is.
After the constitution.
Where is that? 46.
46, man.
46.
Rule 46.
Rule 46, 3, my lord.
Rule 46 of the constitution rules.
Assam Panchayat Constitution Rule 1995. But because earlier, my lord, presidents were directly elected by the public. Now, my lord, it is president and vice president has to be elected by the elected members of the Panchayat, or member of the Panchayat, my lord.
Yes.
46, my lord, election of president and vice president of Gram Panchayat. The deputy commissioner on or the subdivision has your lordship got it.
Yes.
Subdivisional officer has came to my shall be called the first meeting of the Gram Panchayat under clause subsection 1 of the section 6 act by fixing a date by causing a written motion specifying the date, time and place meeting of the so and so. Now your lordship come to 3, my lord. If 1/3 member or more than total number of members call for the meeting under sub rule 1 are not present within a 1 hour of the time fixed for the meeting, the deputy commissioner or the district commissioner, as the case may be, or officer empowered to this shall adjourn the meeting pending execution another date by deputy commissioner on subdivision so and so and so. So that is 1/3. So requirement is 1/3. That is, my lord, already, my lord, held 1/3. What will be the amount of 1/3? That is
Only four, my lord, that is decided by this honorable court.
No,
my lord.
where is that, the shall be minimum 7? From where is it?
My lord, that is their contention, my lord. The
Oh,
contention of the
okay.
respondent, my lord. Now, my lord, your lordship kindly see the division bench judgment, my lord.
Where is the quorum defined, quorum?
Quorum defined, my lord, my lord, by,
No.
no, 18 is not, my lord, they are not applicable to this present case, my lord. So your lordship kindly see that in similar situation, my lord, this honorable court already, my lord, what will be the quorum, my lord, and that will be already, my lord, decided, my lord.
Hmm.
Uh,
No, under the act, is there,
My lord, that is the only line, my lord.
there is no quorum defined?
No, my lord, no, so far is president and vice president is concerned, my lord, no quorum defined, my lord. Only in case of, my lord, general meeting of the, my lord, Gaon Panchayat has been decided, my lord.
Hmm. All right, then?
Then, my lord, your lordship kindly see, my lord, under similar situation, one another, my lord, petition was filed before this honorable court.
Hmm.
That went to the division bench also, my lord, that is, your lordship kindly see page 46, my lord, 56, my lord.
Hmm.
Page 56, my lord. Para 17.
Yes.
In similar situation, my lord, only 4 member, my lord, 6 member out of my lord 10 was present. Even in the assuming the section 18 of the act may not have any applicable in the adjudication of the present case, rule 46(3) quoted above itself is sufficient to govern the first meeting of the Gaon Panchayat. The purpose of laying down the quorum is towards the furtherance of the requirement election president among the elected ward member of the Gaon Panchayat, section 6 of the Act 1994, has undergo a major amendment in India 2023. The earlier position of the president was directly elected by the people has been amended, and presently such president is elected by the elected ward member. But Rule 46(3) quoted above lays down that there should be a requirement at least 1/3 of the total member of the first meeting to be elected the president and the vice president. So accordingly, this petition was allowed. And then, my lord, it was, my lord, they went to the, my lord, division bench. And division bench, more specifically, my lord, out of 10, it is 4 that is decided, my lord. That, my lord, page 63, my lord. Be irritable, my lord. Page 63, my lord.
Yes.
Now, again, that single mess order, my lord, which I have read, my lord, that before this, this order was passed. The decision of the district commissioner, Vishwanath Sareli, calling the proceeding of the meeting
And in this case, how many members were present?
4 members was present.
So in your case, how many members were there? 4.
4 members. So 4, my lord, even it is, my lord, section 18 is applicable, my lord, then also, my lord, I'll be benefited. Even not applicable, even also I'm benefited, my lord. Because 4 member is quorum, my lord, and then that particular meeting, my lord, 4 member was present, duly constituted the body, and that body is, my lord, now, my lord, if your lordship, my lord, see the, my lord, is very concretely, my lord, the division bench has been stated, my lord, spell out. Page 63, your lordship kindly see.
Yes, we have seen it.
I've seen it, my lord. So it is 4 only. So that is why, my lord, I'm submitting before your lordship. Already, my lord, it is that, my lord, deputy commissioner has passed the order that meeting is illegal. That is, my lord, prima facie, that is not, my lord, tenable in the eyes of law, my lord. My submission before your lordship that, my lord, from intimate protection may be granted.
Yes.
But that we 6 members filed caveat, but here 4 person made the respondents mine. But
Where are the caveats? Your name is not there.
no,
You're not arrayed.
we filed the caveat, my lord, it is not on the record, my lord. But here they filed the case against 4 person, fine.
Are you
Out of 6 members.
okay? Are
In
you
WBC.
Are you also arrayed as a respondent here?
Yes,
Okay.
only 4 respond because here 4 respondents, so I'm for 4 respondents. They are, my lord, 6, 7, 8, 9.
6, 7, 8, 9,
Nine.
okay.
Now you look, and I take your lordship, page 9, my lord. Page. Your lordship, paragraph 5.
Yes.
That a presiding officer was duly appointed to conduct the first meeting of 40 number so and so scheduled on 23/6/25. However, upon finding that the requisite quorum was not present, your lordship, the presiding officer postponed the said meeting due to lack of quorum. We 6 members were present on that day, my lord. All the 6 members were present on that day, but that was deferred because due to lack of quorum, taking the 7 in that way, my lord.
From where do you say that 6 members were present?
6 members present, your lordship will find page 44. Page 44. Entry not out. Page 44, paragraph 1, factual metrics. Your lordship got it.
Yes.
The first meeting, my lord, of so and so was convened on 23/6/25 for the purpose of administering oath and election of president and vice president. 23/6/25, out of 10 elected members, 6 members were present. The presiding officer adjourned the meeting citing lack of quorum. Then on 4th, then next date is 4/7/25. This date was fixed for the adjourning meeting. However, no meeting took place as the authorized officer fell ill on 3/7, leading to a postponement of the meeting. 10/7, then 10/7, meeting was held on this day. Only 4 members out of then available 8 members were present. The election was conducted and the Najima and so are declared president, vice president respectively. Out of 4 persons, my lord, the election took place. Then 45, your lord, kindly see page 45. It is a matter of record, your lord, kindly know.
Yes.
It is a matter of record that on 23/6/25, the presiding officer ruled that 6 members were insufficient to constitute a quorum. This administrative decision establishes that the required quorum for this Gaon Panchayat is at least 7 members of Assam Panchayat constitutional rules. That a meeting of the Gaon Panchayat is adjourned if 1/3 of the 4 of the total members to the meeting is not present within the hour, Majma, so and so.
No, but what does the statute say?
Yes.
Statute says only 1/3.
That I'm having, because now court has already decided. I question, my lord, on the first meeting, when we are all the 6 were present, on this ground, that meeting was adjourned, my lord.
But that is not challenged, my
No, not question of challenge, my lord.
No, but somebody misinterpreting a provision will not sanctify the action if it is not otherwise traceable to an act or a rule.
If you kindly see 46 again, madam, subject to what my lord, revision man said, just my lord, for a moment, for 46. 46, my.
Next, please.
Now, of course, it has been interpreted, but your lord, kindly see 3. What does it mean, my lord? If 1/3 or more of the total members are called the meeting.
You're reading from?
Page 46, 3, my lord. It is page 215. If this is the book.
213.
213.
The book 213, man. Page
So,
213.
rule number?
Yes, rule.
46.
Panchayat rule.
46. Yes.
Hey. In my understanding, of course, now court has decided, but for your loss kindly similar. If 1/3 or more of the total members called to the meeting are not present, that is, if 1/3 not present, meaning that my lord, within that hour, then it may be my lord adjourned. Now 1/3 absent out of 10 persons, my lord. If 1/3 absent, then what remains, my lord? If 1/3 absent, then 1/3 is 4. Out of 10 members, 1/3 is 4, my lord. If 4 absent, meeting cannot be held on that ground, that first meeting was adjourned. On that interpretation. If 1/3 absent, my lord, meaning thereby, minimum 7 must be there. This is the meaning of this clause, my lord. As I understand, my lord. Of course, now court has interpreted my lord taking section 18. Section 18 deals with normal constitution, normal meeting, my lord.
After
And after constituting the panchayat. Here panchayat is not constituted, my lord, since president, vice president was to be elected.
What is the strength?
10.
10.
10.
1/3 will be 3 point something.
4.
4.
And on that ground, we are not allowed, my lord, the 6%, we are not allowed to take oath also, my lord.
On the very first meeting.
In the very first meeting. And that appear in the impugn order also.
But what is the quorum for the meeting?
This is the, my lord, 3, if we interpret, my lord, clause 3, 46(3), my lord, the quorum is meaning of my 7. One-third absent.
Meaning thereby if they are present, then 1/3 is enough.
Huh?
In other way around, that's why my lord division bench decided it, my lord.
No, other way, the one-third absent. Absent means,
That means if they are present, then they will be held.
so 1/3 present, 1/3 if absent, and meaning thereby, what?
No.
7, it means 7, 2/3.
In the meeting, how many members were present?
In our meeting, 6 members present in the first meeting. my lord.
No, this
Now, 4
Present
members.
with 4 members, my
Four.
lord. When I will elected, my lord.
4 members. And now impugn order says, madam, simply a press meeting is to be held. So everything will go, my lord. Now democratic process went on. What is the last order, madam? You lost kind.
Division bench has interpreted.
That's why my hands are also tight, my lord. But only thing I got to yes, impugn order, what it says, madam, last part, my lord, last part only. In view of the above, the undersigned in exercise of our so-and-so, opinion that the election of president, vice president, the meeting so is invalid. A fresh first meeting of the so-and-so will be convened for oath taking of all the 10 members and for the election to the president, vice president, so-and-so. So nobody will be prejudiced, madam, if that is there, madam, fresh meeting, let the fresh meeting be held, madam. Because there is conflict between 4 members, 6 members, division bench judgment.
No, there is no conflict on division bench judgment.
No, I'm not conflict because of my interpretation, my
Division
lord.
bench judgment has explained the position qua rule section 18 and
46(3).
So according to division bench, it is section 18 which will have the primacy over the rules.
That is also, my lord, we have not at this stage because that is not challenged. This remains, my
So
lord.
therefore, we'll issue notice at this stage and.
No, my only question, my lord, a fresh meeting is to be, any problem is there, no, anybody will be prejudiced, my lord.
No, fresh meeting for what purpose?
For taking oath, we have not taken oath also even till today, my lord. We have not been.
No, but fresh meeting, why a fresh meeting is to be called?
Because of the, my lord, this.
So you'll have to point out some infirmity.
Infirmity is there because on the first meeting on 23, we are present.
You are present, but.
So at that time, we have said that yes, quorum is not taking the 7 members.
That is not under challenge.
Yes, it is not same.
No, that is, my lord, because it was a continuation. Then it was adjourned. Then again meeting held. Only 4 members. So there's no question of why the challenge. It is a continuation, my lord. It was adjourned, then another date was given, then another date was given.
Now, whatever it is, but division bench has said 4 members is the quorum.
Now, as on now, my lord, because our hands are in that way, my lord.
So therefore, notwithstanding that the six member presence was in that meeting was not taken, subsequently.
So,
4
4 members also same thing, my lord. 6 members quorum was not there. But as per them, my lord, as per division bench judgment, of course, that quorum was there at that time also quorum was
All
there.
right, so we'll issue notice here then. Heard Learned Council for Parties issue notice, Richard, for 4 weeks, Mr. E.M. Ahmed. Sorry, Mr. H. Sharma appears for respondent number 1. No, sorry, number 2, 3, 4.
2, 3, 4.
And Mr. anyone for Panchayat? For respondent number 1 and 5. Mr. H.R.A. Chaudhary, assisted by Mr. M. Ahmed, appears for respondent number 6789. Since the respondents are represented, notices of waived, extra copies be furnished within a period of 1 week from today. The challenge before the court is the impugned order dated 22/12/2025 issued by the District Commissioner Morigaon, whereby the
Declare the meeting 10/7/25 is invalid, my lord.
whereby the meeting for election of the president and vice president
Dated 10
held on 10/7/2025 was declared to be invalid. This declaration was on the interpretation made by the district commissioner that the quorum for the meeting where the total number of members are 10, the quorum for the meeting, minimum quorum for the meeting is 7. And in the meeting held on 10/7/2025, there were only 4 members present. Stop. The effect of this order is that the election of the petitioners, you are the president and vice president.
Yes, president, vice president, other two members.
The election of the petitioners as president and vice president. You are, who's the petitioner here? I'm sorry, president?
President, number 1.
Number 1.
And
Number
who's the
2
vice
vice president.
There's the member present there.
And the petitioner 3 and 4 being members present there. The election of the president and vice president, or election of petitioner 1 and 2 as president and vice president respectively, has been nullified. Learned Counsel for the petitioner submits that this question has already been settled by a division bench of this court by order dated 18/12/2025, passed in writ appeal 411 of 2025. By the said judgment, the order received of the coordinate bench was upheld, and the division bench held that there is no conflict between section 18 of the Act, Assam Panchayat Act of 1994 and Rule 46(3) of the Assam Panchayat within bracket Constitution Rules 1995. Stop. The division bench authoritatively held that the quorum for a meeting as defined under section 18 would be 1/3 of the total number of members. Stop. Learned Senior Counsel for the petitioner therefore submits that if the quorum for the meeting is 1/3 of the total members, then in the case of the which panchayat is it?
Number 4.
40
number Dhamkura.
Dhumkura
Dhumkura
Panchayat,
Gaon Panchayat. Morigaon.
where there are 10 members, the quorum would be 4 members, and these 4 members were present on a meeting held on 10/7/25, and therefore the meeting was validly held, and as a consequence thereof, the impugned order dated so and so passed by the District Commissioner Morigaon, nullifying the holding the meeting to be invalid, is contrary to the provisions of the Act and the rules, as also the order passed by the division bench in writ appeal number so and so so and so. Stop. Better. Mr. H.R.A. Chaudhary, then a senior counsel assisted by Mr. Ahmed. On the other end, it refers to Rule 46(3) and submits that the said rule, a reading of the said rule reflects that if 1/3 or more of the total number of members who are called to the meeting are not present, within 1 hour of the time fixed of the meeting, then the deputy commissioner or subdivisional officer or the officer empowered, as the case may be, shall adjourn the meeting pending fixation of another date by deputy commissioner or the subdivisional officer. Sorry. Then the senior council therefore submits that a reading of Rule 46(3) does not reflect that the quorum specified under the rule is 1/3. Rather, the rule mandates that if 1/3 or more members are not present, then the meeting is to be adjourned. He therefore submits that in the present proceedings, where there were 10 members required to be present in the meeting, 1/3 of the members will amount to 4 members. And going by Rule 46(3), if 4 or more members are not present, then the meeting ought to have been adjourned. This is your submission?
Yes.
And therefore, there is no infirmity in the imperial order dated.
And 23-6 were present by the lordship.
Passed by the.
Page 44.
Passed by the deputy commissioner. Stop. He further submits that on page
44.
That on 23-6. 23-6.
Yes, ma'am. 26-25.
25.
Yes.
Out of the 10 elected members, 6 members were present. But the presiding officer adjourned the meeting, saying it was a lack of quorum. Therefore, the election ought to have been held on 23/6/2025, when there was a valid quorum for the meeting. However, the same was adjourned, and finally on 10/7/2025, meeting was held by the presence of only 4 members, which, according to Rule 46(3), does not satisfy the quorum. He, however, submits that he would like to address the court on the judgment rendered by the writ appeal.
Yes.
In this regard. Accordingly, notice issued only. Accordingly, considering the submissions made, let notice issue returnable 4 weeks. Since the respondents are represented, notices are waived, extra copies we furnished within 2 working days. Respondents may complete their instructions and file necessary affidavit till the next returnable date. The imperial order dated so and so shall not be given effect to. 22/12/2025. The matter is made returnable on.
Development also, they have not taken oath, my lord. They have not taken oath till.
We have taken
oath. So development, present development also comes at what date, my lord?
On 20 February.
20.
20.
Obliged to. Panchayat, my lord.
Yes, we have already recorded your name. Your caveat is there, no?
We appeared, my lord, on basis.
All right, so we are not recording, we are not discharging the caveat because it is not available.
Yes. File simple.
No. Alan is ordered to file it. We are disposing of these matters. Heard counsel for parties disposed. We do silo, Google Drive out. Where the appeals are filed, appeals have been dismissed. Officer ordered this evening. 20, 21, 22, 23 order. Yeah.
In item number 17, there is no appeal only. In item number 17, there is no appeal.
Item 17.
There is no appeal.
Okay, disposed of in terms of this order.
Lordship, I am
passed in
appearing-
WPC 69 of 26.
I am appearing only in item number 15 and 18, Lordship.
Mr. B. Chaudhary for item number 15 and 18
Yes,
for the
Lordship.
state GST.
Yes.
And Mr. K. Jain for
16, 17 and 30
16, 17 and 18.
for the sentences. I am for Union of India, 16 and 17.
Learned CGC has entered appearance for Union of India. In item 16 and 17. All right.
Much obliged.
Yes, where is
Someone is
the
appearing
income
from the
tax?
income tax also.
Yes, why have you not released the bills?
We have not received the copy and our name is also
What copy? You give him a copy, extra
Yeah,
copy.
Lordship, copy is not another problem, but they are all aware, Lordship. Scan copy already sent in the mobile, registered post to speed post.
No, to the council.
Yes, Lordship.
Have you sent it to the council?
No. Yes, at the time of filing, they have.
Has he
I'll-
received
I'll
it?
serve.
Give him a copy. The learned counsel for the petitioner in person will serve extra copies of the writ petition on the standing counsel, on the learned counsel appearing on behalf of the standing counsel for income tax, Mr. K. Jain,
Lordship.
2 and 3.
for respondent 2 and 3, MS, so
M. Burman on
M.
behalf of
Burman
Mrs.
for-
A. Gayan. On behalf of Mrs. A. Gayan.
MS A. Gayan appears for respondent number 1. The standing counsel will obtain required instructions as to why the professional bills raised by the petitioner in person for services rendered on behalf of the income tax department before the representing the department in court proceedings have not been settled. Let this matter be listed again on 13th February.
Obliged.
The name of the standing council income tax may be.
You note it, we are fixing on 13th.
Lordship.
Name registry will reflect the name of standing council income tax.
Much
for the
obliged.
respondents.
21.
This is bench 4 matter.
Yes, madam.
Matter be listed before the appropriate bench as it is submitted that this is a matter pertaining to civil bench 4. Registry to verify and do the needful.
Obliged, madam. Motion item 54.
Yes.
Lord,
Done.
we have challenged the Lord import notice that your Lordship will find at page, my Lord, 18.
18.
Yes, page 18. Now, date was fixed, my Lord, on 23rd 1/2026 for eviction. But due to the, my Lord, ensuing, my Lord, SSLC and HS exam, that eviction has been, my Lord, deferred till the, my Lord, exam. Now, that notice subsequently, my Lord, another notice Lordship will find at page 20. Yes, the same date, my Lord, 23rd January 2026. Now, after that, my Lord, we filed, my Lord, a representation before the, my Lord, district commissioner that your Lordship will find at page 36. Saying that, my Lord, we are landless because of, my Lord, erosion by the mighty Brahmaputra river and, my Lord, Manas river. Page 36.
Yes. I think this also you'll have to dispose it of by giving them opportunity to examine. The notices issued do not appear to give any opportunity for filing their reply or response.
No, it is there, my lord,
Huh?
at page, at page 21, if Lordship is taking.
21,
Yes,
yes.
page 21. That is the, my lord, first of those notices. Page 21, my lord, the second paragraph.
Okay.
উক্ত ভূমিৰ ওপৰত অধিকাৰ সম্পৰ্কে আপোনাৰ কিবা বক্তব্য আছে তেনেহলে অহা ইংৰাজী 23/1/2026 তাৰিখৰ আগতে নিম্ন স্বাক্ষৰকাৰী কাৰ্যালয়ত উপযুক্ত নথিপত্ৰ সহ দাখিল কৰিবলৈ কোৱা হয়।
And you did not submit
We have submitted
before circle officer.
before circle officer as well as district commissioner also.
Then,
Then, my lord, that is pending, my lord.
so decide it.
Yes.
But they have given,
So you get your instructions.
perhaps we need to take the instructions
Yes,
because my lord, this representation, lordship will find it at my lord page 36. Page 36.
Yes.
Page 36 is only a type copy. So we do not know whether
original.
any such representation has been filed, at
No.
all filed.
These appear to be signed.
No, it appears to be signed, but my lord,
It doesn't say it is a type copy.
It was through one line, my lord, and in addition to that, my lord, hard copy is also there, my lord. We have submitted.
There is no acknowledgement.
With acknowledgement, my lord. You will file, my lord, that acknowledgement copy.
You file it.
Well,
Let them file an additional affidavit immediately, my lord.
The petitioners are aggrieved by the ensuing notice issued by the circle officer, Boitamari Revenue Circle, Boitamari, in the district of Bongaigaon,
Bongaigaon, my lord.
whereby the petitioners are sought to be evicted from their villages, which the respondents claim is government khas land at village Oreya Pahar, Horal Kundi Bill, Konora Bill, and Doloni Bill.
In fact, these are wetlands, my lord, as depicted from the notice. Water bodies and wetlands are exclusively barred, my lord. No one can come into.
Petitioners claim to be flood erosion affected persons, displaced persons, and they have been residing in these places for several years. Nevertheless, in pursuance to the notices, impugn notices issued, petitioners had submitted their response and representations before the concerned authorities, including the Deputy Commissioner Bongaigaon. Stop, however, no orders have been passed by the authorities concerned. In response to the said representations filed. Yeah. The counsel appearing for the respondents, Mr. Borpuzari for the Revenue Department and Mr. H. Sharma for Government Advocate will obtain instructions as to the status of the representations or response filed by the petitioners to the notice, impugn notice dated so and so. Petitioners, in the meanwhile, are also permitted liberty to file, to bring on record any additional documents they feel would be relevant for deciding the issues raised in the present petition. Let the matter be listed again on 6th February.
My lord.
6th
6th of February, yes, my lord.
till the next date fixed, status quo between the parties will meet.
Let them furnish by today itself.
Yes,
my lord.
Serve extra copies during the course of the day.
my lord, so that. But second item is also identical, madam.
Identical,
Yes, same notice.
Purban.
Yes,
55.
same area, same notice.
56.
Diploma.
I am obliged.
Yes. 55 is also same, huh?
Lordship, here the petitioners, Lordship, they were running some business in the room allotted by the Pandya Gaon Panchayat, Lordship. And since last 20 years, some are running since last 20 years. Now they have been served with a very short notice, Lordship.
Where is that?
That, Lordship, will start from 31, Lordship, it's 31.
There is a representation behind.
Oh,
From 30, Lordship. Within 7 days, they want us to vacate the, so we want some time only, Lordship, nothing more.
We'll vacate it. Lordship.
Not 7 days, Lordship, it's 10 days.
Lordship, it was issued in 20, but we were served on 22. I have made a statement, Lordship.
You are agreeable to vacating it?
No, I am agreeable to vacate it.
All right, heard counsel for parties.
Lordship,
The petitioners before the court claim to be persons who are running their businesses from the rooms allotted to them by whom?
By this Gaon Panchayat.
Bandia Gaon Panchayat, situated in Bandia, Mongoldoi in the district of Dorong. They have been running their businesses from the said rooms and paying the necessary rent. The counsel for the petitioner submits that on 2001-2026, by way of the impugned notice, they were asked to vacate within 10 days, fixing 3001-2026 as the date for vacating the premises stop. Although certain issues have been raised in the writ petition, the counsel for the petitioner on instruction submits that they are agreeable to vacating the said rooms, but they need further time
Finding a suitable accommodation.
for finding alternative accommodation. Stop. Under such circumstances, without addressing the issues on the merit, this writ petition stands closed at this stage without issuance of notice also. Directing the petitioners to vacate the premises within
At least
20 days from today.
30 days. Lordship. 1 month. 1 month, Lordship.
no, 1 month to 2 months.
1 month is too much.
Because Lordship, we
You have
have to
already
find-
got 10 days. I am giving you another 20 days.
Lordship, only 10 days. maybe.
20 days from 30.
Lordship, we give 1 month, Lordship, we'll vacate it.
You have got 10 days.
Yes, Lordship.
It expires on 30. From 30,
Only
we'll
that
give
month
you
of-
another 20
Only
days.
month of February we want, Lordship, we will vacate it.
No, not like that. You vacate it. If you are agreeable, vacate it. Further 20 days from 3001-2026. Stop.
That means it will extend from 30 to Lordship.
From 30,
Yes.
another 20 days. The writ petition accordingly in terms of the above stands disposed of. Mr. Ricky Ghosh appears for the respondents.
Right, Lordship.
Copy of this order be marked to the Office of the Standing Council, Panchayat and Rural Development. Mr. H. Sarma for
Respondent number 2.
respondent 2. Yes.
Present.
It is for others, item 39.
But please, your lordships, my lord, we have been newly engaged, my lord. That is why I am praying for adjournment. And matter may kindly be fixed on 19th of February.
Your Mr.
J.H. Soikia.
J. H. Soikia.
Soikia.
Counsel submits before the court that he been recently engaged in the matter. And he therefore prays for some time to complete his instructions. Mr. B. Chaudhary for the respondents do not object to the prayer made. List on
19th February.
19th. All right, 19th February.
Items 40 and 41.
My lord, I think both the sides will be
Hmm?
praying for time being, my lord, because
4041 on the request made by the counsel for the petitioner stands deferred to be listed after 2 weeks.
No, my lord, time being, my lord.
time being.
Or time being,
Yes, my lord.
not time being today, next
Lord,
week.
My lord, my lord.
Next week,
Then my lord, Friday, my lord.
not
There
Friday.
is Easter, there is Easter.
Oh, then let it be on Monday, 2nd. 2nd,
Mr. Chaudhary is waiting a long time, my lord.
we can't help it. We're
My
not
lord.
timing today.
But then Friday, my lord.
Friday, all right, Friday. Be taken up on Friday. Negative. Hmm.
42.
Well, then item,
What,
item 42.
Uh,
In item 42, my lord, I have filed the IA for vacating this stay
My lord,
order.
in that 41, my lord, if any interim passed earlier shall continue.
Any interim order passed earlier will continue till the next date fixed. Yes.
My lord, we have filed the IA for vacation of the interim order.
Hmm.
They have filed an objection today. And some urgency is on our part, my lord. If the objection is not on record today, so my lord, maybe taken on 4th, my lord.
The counsel for the petitioner, applicant submits that the application is filed for vacating the interim orders. The objections have been filed by the respondents, which however is not on record. List this matter again on
Can it be on 4th, my lord? 4th of
fourth of
Lordship.
February.
Lordship.
None appears, so the petitioner passed over. Passed over. Mr. Rich Sharma for the respondents.
Item 60.
Same order. None appears, passed over. Why review?
My lord, Lordship, my lord, Lordship's order dated 6/1/2026, my lord. Lordship has directed the board to take up the matter before director and take the decision on the ROP. In fact, my lord, there is an affidavit by the board that this is not been adopted, not been implemented. That part has been suppressed, my lord. Lordship will kindly turn to page number. These minutes has not been taken, brought on record, my lord. Lordship will turn to page number 84. This is the minute dated 15 July 2019. In fact, the board has on that particular day has adopted it, my lord. Agenda number 3, Lordship will file it in page number 85, next page. 85.
So who was supposed to bring it on record?
This is the board, which is not within our knowledge, my lord, at that particular point of time.
Why did you not bring it on record?
And this is not in record, my lord. The board has already adopted it on 15 July 2019. Thereafter, another Lordship will agenda number 3. Lordship will go to the agenda number 3. Final portion, last portion. Board after threadbare discussion approved the decision of the adopting the revision of pay scale ROP 2017 to the board employee. The board also decided to submit the proposal release of salary, etc. of the office and the staff of the Housing Board as per ROP 2017 to the department as per instructions.
Then what happened after that?
After that, Lordship will find another minutes took place. Another meeting took place. Lordship will find in page number. It is dated. Page number 87. It is dated 19 August 2020. Lordship will come to page number 88. Down below, after second subparagraph of paragraph number 4. The Commissioners Assumption Housing Board have also informed in the meeting that the department had received 263.67 lakhs to the board as granting it under revenue head of accounts for the year 1992 and will be adjusted for the meeting under salary requirement or subject to implementation of ROP.
The board is required to pay it.
The board has received that amount from the government.
But government liability will be nil.
Government liability will be nil, but board has received that amount for implementing ROP. Once they have adopted it, in the subsequent meeting, they have said that this amount has been received. And these things have not been brought on record.
Yes, what do you say?
Lordship, I have filed an affidavit in opposition as per instruction of the.
No, affidavit where?
Lordship will
in the
find
writ petition.
In the writ petition, Lordship.
No.
Lordship, this matter, if
You
it is
get your
correct,
instructions.
Lordship,
Heard Mr. S. Bora, learned counsel for the petitioner. This review petition is directed against the order dated
6/1/2026.
6/1/2026.
Lordship will find page number 78. 26.
1/26. Passed in WPC 2644 of 2023, which came to be disposed of with a direction to the Assam State Housing Board to take a decision with regard to the payment of the revised pay as per ROP 17.
17.
Stop. The review petition has now been filed to bring on record certain resolutions which are stated to be adopted by the board approving adopted by the board as regards the payment of the revised scale of pay as per ROP 17 to the employees of the board and the said amount and in order to discharge the said liability, financial benefit from the state government has also been received. Stop. Learned Counsel for the review petitioner submits that this information ought to have been placed before the court by the Housing Board in their affidavits which were filed in the writ petition. However, the same not having been brought and subsequently having come to the notice of the writ petitioner, the present review petition has been filed. There are issue notice written up to 4 weeks. Mr.
T.R. Gogoi.
T.R. Gogoi appears and accepts notice on behalf of the sole respondent. All the respondents. Therefore, notices are waived. Extra copies be furnished within a period of 3 working days. The matter be listed for orders on 13.
And in the meantime, a lordship order is not kept in a
Pendency of the review petition shall not be a bar.
No. This lordship will keep that particular order data once in advance. Otherwise, they will hold a meeting and proceed some other decision they take it, my lord. Because that is complete complaint contemplated, my.
Till the next date, the directions issued in the order dated so and so, passed in WPC so and so, shall not be given effect to by the respondent board.
In fact, while deliberating that order, my lord, my friend was asked, he also informed that it was not adopted. In the affidavit also it was not have.
Also, I don't know how he collected this. Actually, it is correct that then I was also kept in darkness. Also.
You have to confront your client.
Yes, Lords.
Yes. Yes.
They were supposed to file reply. I will file it next week.
Council for the Forest. Mr. A. Botakur. I Botakur, Council for the Forest Department will praise for further time to file the affidavit. Prayer made is not objected to. List again after 2 weeks on 23rd February. Yes.
Lord, I have a biryani shop, my lord, under the name and style as MS Shahi Biryani at Nilbagan Huzai, my lord.
So affidavit
has been filed, my lord.
Has been filed, but not connected even today.
We have filed our affidavit.
It's not available here.
Order, my lord, only reply file. No, nalage reply dibo.
But our affidavit is filed on 20th of
20
December.
But the office note dated so and so says that no affidavit is filed. Heard Mr. A. Counsel for the petitioner, Mr. H. Sharma, additional senior government advocate, submits that the affidavit on behalf of the state has been filed on 20.
20, it is reflected here. Maybe some defect is there, Lord. So we
2025. Stop. The office note, however, dated 19/1/26 reflects no affidavit has been filed. The registry will will verify and inquire as to whether the affidavit has been filed by the state, and if so, the copy of the same be traced out and connected to the writ petition. List this matter again on 9th.
Lord, it will be some says there, my lord. Lord,
Some time has to be given.
My lord, my whole shop, my lord, what has happened is under lock and key. This is the only source of earning, my lord.
Bear it for another week. You have to give the minimum time for 1 week.
Clients are. my lord,
Your customers will have to go without biryani for 1 week,
My lord,
more.
my lord,
Ask them to wait.
my lord.
Too much of biryani is also not good.
Not good, my lord. Highly obliged. my lord.
Lordship, here I have just now received the instruction, but it lacks clarity, Lordship, 1 week time, Lordship.
Mr. Harish Misra for the petitioner, Mr. B. Chaudhary for
State GST.
State GST, Mr. A. Jain for Central GST, CGST. Mr. Chaudhary submits that he has received some instructions which however are incomplete. He prays for further 2 weeks' time. List again. On 27th of February, interim orders, if any, passed earlier will continue till the next date fixed.
Much obliged.
Or admission of vacancies, please don't.
Please, Lordship, the notice is duly served. The reply is yet to be filed.
Yes.
We are awaiting instructions, my lord. Another 3 weeks may be granted, my
Lordship,
lord.
kindly short date. It's being a long pending matter.
But they have filed the writ petition after 24 years, my lord.
This is for what?
For a land acquisition
acquisition.
compensation, my lord. We need to verify some records, my lord. Though instruction has received, but it is not sufficient enough to file the affidavit, my lord. That is why I am asking little more time, my lord.
MS Burman Learned State Council prays for further 2 weeks' time to complete her instructions. Council for the petitioner does not object to the prayer made. List again after 2 weeks. List on 18th
Lordship.
February.
Lordship, item number 63.
Same.
Same.
Same. List on the same date. Well,